to the June 2019 meeting of the Zoning Hearing Board. To begin, I would invite everyone to join us in the Pledge of Allegiance. Thank you. A couple procedural items before we get started. We are going to continue two cases that are on the agenda for this evening. The first case, Appeal 3041, the applicant James and Christine Flynn, property located at 236 North Aberdeen Avenue, zoned R5 residential. That case is going to be continued to the July 18th meeting of the Zoning Hearing Board. Also, Appeal 3042, which is the applicant All Seasons Flowers and Produce, property located at 912 Conestoga Road and zoned Garrett Hill CR. Applicant conducts a florist and related services at the property. That case will also be continued until the July 18, 2019 meeting. If anyone is here specifically for those cases, we welcome you to stay for the remainder of the entertaining program we're going to put on for you this evening, but those cases are continued. Moving on, appeal number 3043. The applicant, the Grayson School, property located at 209 and 211 Madsen Ford Road and zoned R1. Applicant seeks a special exception from under section 280-101A1 and or 280-101A2 of the zoning code to allow the continued or expanded educational use of a portion of the property by the Grayson School, a private school servicing gifted children grades pre-K through 12, and any other relief deemed necessary for the Grayson School to occupy portions of the Archbishop John Carroll High School campus. Is council ready to proceed?
I am.
Thanks.
Good evening. My name is Dan Rowley. I am an attorney representing the Grayson School, a school for gifted children which desires to move from Marple Township to the Archbishop John Carroll campus here in Radnor. George Brosman of my office, who filed the application, could not be here tonight due to a scheduling conflict. With me this evening are Mr. Francis Fox, the president of Carroll, and Melissa Bylash, the executive director of the Grayson School. I will be calling Frank and Melissa to testify, but before I do, I have some opening remarks and some exhibit packages I'd like to hand up.
Certainly.
The Archbishop John Carroll campus is located on a large tract of over 50 acres of land located along the Madsen Ford Road, zoned R1 residential district. The Carroll was approved in 1965 by virtue of the orders of the Delaware County Court of Common Pleas. Copies of that order are attached in your exhibit packages at Exhibit A1D in the Zoning Hearing Board application that we filed in this matter. At the time of the application for Carroll to build its campus, the R1 Residence District permitted educational uses by special exception. The R1 Residence District provisions in effect at the time are found at Exhibit A2. And you can see in Section 301.3 of those provisions that educational uses were permitted in the R1 Residence District by special exception. After the filing of the application for the Carroll campus in 1964, the township amended the R1 district provisions to eliminate educational uses as a permitted use. Accordingly, the educational use of the property is a lawful non-conforming use. The evidence will show that when the school was approved by the court, it was anticipated that there would be approximately 3,000 students served. These facilities located at Carroll today were built to accommodate these levels. Mr. Fox will testify that the school indeed reached enrollment levels of approximately 2,400 to 2,500, but enrollment now is approximately 700 to 800 students. In fact, when Carroll opened in 1968, it operated as two separate schools. There was Archbishop John Carroll High School for boys and Archbishop John Carroll High School for girls. These two schools were joined as a co-ed institution in 1986. Pennsylvania law provides that a constitutionally protected right for non-conforming, that it is a constitutionally protected right for non-conforming uses to continue and expand. We believe that the Grayson School use of the portion of the underutilized Carroll facilities qualifies as a continuation of the nonconforming educational use of the campus. Under Pennsylvania law, in order for a use to be considered the continuation of a nonconforming use, similarity in use is all that is required, and the doctrine of natural expansion, it must be given effect. The Pennsylvania Supreme Court has stated, in fact, that the nature of the nonconforming use must be determined from the actual use to which the property is being put rather than the identity of the users. Out of an abundance of caution, we applied for relief under both Code 280-101A1, which provides that a continuation of a nonconforming use that involves a change of occupancy is deemed a change of use permitted by special exception, and Code 280-101A2, which allows for an expansion of a nonconforming use also by special exception. Given that the Grayson School will use space already devoted to educational use for educational purposes, we believe the proposed use is clearly a lawful continuation of the nonconforming use. We would also note that the provision of 280-101A that deems a mere change of occupancy appears to be inconsistent with the rights to continue a nonconforming use as enunciated by the state of Pennsylvania. Notwithstanding that fact, given that the campus was designed to accommodate 3,000 students and the proposed use of the facilities by Carroll and Grayson combined will not approach these levels, this application should easily meet the standards of the Code Section 280-101A, that there will be no greater detrimental impacts to the neighborhood and the surroundings than the approved use of Carroll itself. I would now, unless there are any questions, I would now like to call Mr. Fox.
I do. Francis Edward Fox.
And Mr. Fox, can you state your business address?
Our business address is 209-211 Matson Ford Road, Radnor.
And what is your affiliation with Carroll?
I'm the president of Archbishop Carroll.
And can you describe Archbishop John Carroll?
Archbishop John Carroll is a four-year secondary school, Catholic high school, under the umbrella of the Archdiocese of Philadelphia.
And has Carroll entered into a lease with the Grayson School to occupy a portion of the existing educational facilities at Carroll?
They have.
And turning to Exhibit A1A, Is this a copy of the redacted lease between Carroll and the Grayson School?
It is.
And is Carroll a co-applicant in this matter?
We have joined the Grayson School as a co-applicant, yes.
And are you generally familiar with the use that the Grayson School will provide at Carroll?
I am.
Okay. Does the Grayson School hope to start classes at Carroll by the start of the 2019 to 2020 academic year?
They do.
Okay. Drawing your attention to Exhibit A3, which I have blown up and put on the table. This is an aerial photo that was provided to us by Mr. Kachansky from the Township GIS system. Mr. Fox, does this aerial photograph depict Carroll and its campus and its immediate surroundings?
It does.
Can you describe the campus for me?
The campus is approximately 55 plus acres with frontage on Matson Ford Road. It's also bordered by the R5 and the R100 SEPTA lines. It has approximately 5 athletic fields. There's approximately 200,000 square feet of floor area in academic wings, auditoriums, and gymnasiums, with one outbuilding referred to as the Christian Brothers House on the bottom left of the property.
And using Exhibit A3, can you identify the portion of the existing building that the Grayson School will occupy?
Yes, so on the left-hand side of the main building, the black covered
Mr.
roof.
Fox, it may be easier
Oh,
to
great.
use this pointer. If
Right
you
up?
just
Oh, here.
point on here, it'll show.
Oh, okay. Isn't that neat? Okay. Okay, so this wing here is referred to as the B wing. That is one of 2 academic towers that are identical in square footage and number of floors, 4 of them. And it's on the east side. This is the former boys' side of the building. The Grayson School, per their lease, has the bottom floor of the B wing and a very small portion of the second floor, 3 classrooms there, and 2 labs, all in that wing.
And will the school also have use of any recreational facilities?
They will. The lease provides for access for Grayson to use throughout the day, gymnasium space, auditorium on occasion. You can see the former tennis courts. They are now gone, and that is one small athletic field that, per the lease, is provided exclusively for Grayson.
And does Carroll's buildings have all the typical facilities you would associate with a high school and a campus of this size?
I would say yes and more. Because we're 2 different schools, we have pretty much 2 of everything: cafeterias, gymnasiums, our music programs, 8,000 square feet on either side of the auditorium. So I would say it meets all the standards of a school and perhaps a little more.
And based on your familiarity with the Grayson School and Carroll, is their use similar to what the facilities that they will be using at Carroll are today?
I would say they are. Their use is a bit expanded by way of grade and the type of student, but overall, I would say the uses are very compatible.
And drawing your attention to Exhibit A1D, is this a copy of the 1965 court order that originally approved the school at this location?
It is.
And is it your understanding that in addition to the approved 3,000 students, this court order also anticipated a stadium of approximately 3,000 to 5,000 seats?
It did.
Okay. And at the time that the school opened in 1968, did the campus actually operate as 2 schools?
It did.
Okay. Historically speaking, was there ever a time when enrollment reached close to the projected level of 3,000?
It did. In the mid to late 70s, we were well over 2,000 students.
And what is the anticipated enrollment for the upcoming school year, 2019 to 2020?
Approximately 710.
In your opinion, will the facilities accommodate the Grayson School without causing any detrimental impacts to the community?
Yes, quite easily.
In your opinion, would the Grayson School's use of portions of the underutilized Carroll facilities cause any greater impacts than Carroll's use of these facilities to the neighborhood and the surroundings?
It would not.
I don't have any further questions.
How is the space that's going to be occupied under the lease currently used?
They're currently used as classrooms, and we're going to be moving those classrooms to many of the, actually, it's an opportunity for us to put departments together that aren't today. So we have several empty classrooms, and we're moving them so Grayson can have their own exclusive area.
I just have a question for you. Excuse me, will there be a separation between the two schools?
There is. There will be ingress and egress by Grayson to areas. The labs are on different floors, and there's 3 floors upstairs. But for the most part, we are separate.
And what about the age of the children? Carroll right now is high school, correct?
That's correct.
Yeah, and so they say in their application pre-K through 12.
That's correct.
So will there be a separation, and maybe it's a question for your counterpart, but will there be some separation based on age?
Yes, and they could answer, I think, a little better than myself. Thank you.
Mr. Fox, I have some questions regarding what the impact will be for like traffic, for example. Understanding that you have been given permission to have up to 3,000 students. You have 710 for September. How long has the school been at that level or close to that level?
It's a very good question. We haven't been at that level for some time. We lost, for an example, a senior class of 289 being replaced by 170. So we lose 100 parking spots right there with seniors. So it's the lowest student body that we've had in some time. Our plans are to grow that to about 800, 200 per class. But as recently as 3 years ago, we were 1050.
Okay, and again, this may be for the next witness, but how many students will be coming in from Grayson?
I have an idea of that answer, but I prefer Grayson to answer that specifically for you, if that's okay.
Okay, thank you.
Thank you.
Could you give us a sense currently at what you would consider peak use, which I guess is during a regular school day? How is your parking occupied? Would you describe it as half occupied, 3/4 occupied, fully occupied?
Before the senior class, with the senior class that we just lost 3/4, it'll be closer to 50% next year.
It's also a separate dining room, cafeteria too?
Yes. Grayson will not be dining with our students. Thank you.
I'll take that. And with that, I'd like to call Melissa Bylash.
I do. Melissa Ann Bylash, MELISSA
And Melissa, could you state your current business address for the record?
We currently reside at 35 North Malin Road in Broomall, Pennsylvania.
Okay. And drawing your attention to Exhibit A4, is this a copy of your resume or CV?
Yes.
And what is your affiliation with the Grayson School?
I am the founder of the Grayson School and currently serving as the executive director or head of school.
And when did you found the Grayson School?
technically founded the Grayson School around 2000, and it took me about 2 years to get the Articles of Incorporation done, so paperwork would say 2012.
Okay. So just to clarify, 2010, but the paperwork would say 2012?
Yes.
Okay. And can you describe why you founded the Grayson School and what it is?
Yes. I had a private practice of ed consulting, and I was federally trained, and that federal training allowed me to go into any state that I wanted to go to and help families navigate educational systems. And no matter what state I went to, I kept finding a particular problem with schools, public and private, not being able to meet the needs of gifted students. So there's no IDEA funding, there's no obligation for an independent day school to meet the needs of gifted students. So I got a volunteer team together, and over the course of 3 years, worked with a volunteer team and opened the school to meet the need in the Philadelphia suburban area for gifted students.
And is Grayson a Pennsylvania nonprofit corporation?
It is a Pennsylvania nonprofit corp, yes.
And drawing your attention to Exhibit A5, is this a copy of the Articles of Incorporation for the Grayson School?
Yes.
And has Grayson been recognized as a 501c3 organization by the IRS?
Yes, happily we have nonprofit status.
And turning your attention to Exhibit A6, is that a copy of the letter from the IRS stating that?
Yes, it is.
Okay. Does the Grayson School have a license from the State Department of Education as a private academic school?
Yes, we are licensed pre-K to 12.
And I know you did already state this for the record, but where is the Grayson School currently located?
35 North Malin Road, Broomall. We are subletting building space out of St. Luke's. In
And excuse me,
Broomall.
that's right outside of Radnor Township.
It is.
correct?
One
Yeah.
could be on one side of the street and be in Marple Newtown Public Schools, and one could cross the street and be in Radnor.
And that's in the St. Luke's Greek Orthodox Church, is that correct?
That is correct.
And what type of facilities does Grayson have there?
We have about 14 classrooms. It's my understanding that they built the building to be a Greek school, and then did not necessarily have the bandwidth at the time to file all the necessary paperwork to start a private academic school. So then they had this beautiful building and no tenant. So they have like Weight Watchers twice a week and Greek men's group twice a week for about an hour. And then we were able to have a really nice relationship where we helped give them some revenue and we took some space.
And what is the school's relationship with Marple Township?
I would say healthy. We went in front of Marple 3 or 4 times because our first set of licenses was K to 6, then we did 7 and 8, then we did pre-K, then we did the high school as a whole.
And can you describe for the board why the Grayson School wants to move to Carroll's campus?
Well, we wanted to be in Radnor from inception, and the things that Carroll's campus can give us are things that, quite frankly, a year 4 school would never be able to afford. So fields, athletics are really important for whole child development, regardless of the child's academic ability. They need to be able to run and play and be on teams. Most importantly, though, the building that I'm currently renting is about 15 10 by 10 classrooms with no labs or real gym or real auditorium. So we have a high school that's developing and growing pretty much each day. And next year we would be able to run chemistry in a chemistry lab, not chemistry in a kitchen, and physics in a physics lab, and bio in a bio lab, and things like that. And to answer your question, if I may, we have plans to be able to cocoon off that lower elementary school. So pre-K to 5 will be taking on the first floor as a whole. And there's a cafe in there that we will be very simply building, but all of their needs will be met either outside or in that first floor with doors and keys and locks so that their high schoolers are not interacting with our youngest students.
And when does the Grayson School plan to move?
We've hoped to be open in September in this space.
And you heard Mr. Fox describe the areas of Carroll's campus that Grayson will be utilizing, is that correct?
Correct.
Okay. Can you generally describe how Grayson will use this space?
Yes. So the way that the leases right now are, elementary will be in that first floor area, and then our older school children, as they're matriculating, will then have access to 3 classrooms on the second floor, the bio lab on the 3rd floor, and the chem lab on the 4th floor, and then we would just be able to run everything that we needed to run to be a fully functional academic high school in that space.
And what would the Grayson School's regular hours of operation be?
Our instructional day is 8 to 3:15.
And does that coincide with Carroll's hours of operation?
I think it complements it. I did not intend to time it in that way. So Carroll is 7:45 to 2:25, and our instructional day is 8 to 3:15.
And was this done to stagger departure times to avoid traffic problems?
I would honestly say under oath it's serendipity.
Okay. What are the proposed student enrollment levels?
We are headed into year 5 with approximately 100 students. We hope to cap that year at about 110.
Okay. And how many full-time staff do you currently have?
We have a very low student-teacher ratio, so we have 23 full-time staff. No, 23 full-time staff and 5 part-time staff.
Okay. And projecting out, how many would you anticipate on having?
If everything went very, very well from an admissions perspective, we would gain about 20 a year.
And in the space you'll be occupying, how many classrooms are anticipated?
17.
And what would the general capacity of those classrooms be?
Well, I did this math on a calculator, and the square footage requirement from the Pennsylvania Department of Ed for high schoolers would allow 46.6 high schoolers in a Carroll classroom. We run our student-teacher ratio at no more than 10 to 1. Most of our classes are very, very small.
And will you be making modifications to the space that you're leasing?
We hope to make very minor modifications because if the class can hold 46.6 children, and I have a math class of 8 to 1, I would want to do some drywall and framing to be able to afford 2 math classes in that same space, by example.
And for that work that you just mentioned, would all required permits be obtained from Radnor Township?
Absolutely.
And will it be necessary to obtain a modified license from the State Board of Education to move into Carroll's campus?
Yes.
Okay. Do they review plans, inspect space prior to occupancy to ensure that the space is adequate and that applicable regulations for a school of this type are satisfied?
It is an appropriately exhaustive requirement. So they will come out and they will take pictures of all of the books that I have and all the books in the library and all of the graph paper and all of the bulletin boards and all of the number 2 pencils and Mead notebooks, and they take that process from the curriculum down to the actual things as well as the square footage appropriately, very, very seriously.
And does the State Board require confirmation from Radnor Township that the school use is permitted before they will revise the license?
100%. Zoning is one of the top 3 things on my 50-point checklist.
And did you just recently become aware that the zoning hearing board approval would be required due to the status of Carroll's campus as a non-conforming school use?
Sadly, yes.
Okay. And is there a scheduled meeting tomorrow on June 21st at the State Board of Private Academic Schools where the Grayson Schools application will be considered?
I I believe that to be accurate.
Is it important to obtain this approval as soon as possible so that you can open for the 2019-2020 academic year?
Yes. I'm smiling because we joke with the children that they should make a time machine.
And in your opinion, would the Grayson School's use of the portions of the underutilized Carroll campus cause any greater impacts than Carroll's use of these facilities to the neighborhood or the surrounding area?
I believe no.
Okay. I have no further questions.
Thank you. Just a couple questions. First, what's the geographical area from which your student body is drawn?
We draw everywhere. We have families that plan to commute next year from Princeton, from Bethlehem, from Lancaster. It is the only school for gifted children in the whole state. So the broad dots on my map are all within the 10 miles to afford busing, but we go as far out as Lancaster, and next year as far out as Princeton for the. So if you ask me, I think it's double digits worth of zip codes for the school.
So then how are our students typically transported to and from school each day?
Most of the parents drive by choice. And then again, if you're driving from Princeton to Grayson, there's no bus that would have you. So they would be well out of the 10-mile radius.
And in connection with an earlier question, the purpose for my question is to assess the additional traffic in the area at times of, the beginning and the ends of days. So how many families do you have? I suspect perhaps a lower number than the head count on students, but roughly the same number of families that are transporting a student to or from the school?
I'd say out of this year we had 71 students, about 65 families, and of those about 20 drove. So the further the family is, the more likelihood that the drive would be. The only other thing that I would add is that our upper school program, our high school, does not have instructional hours till 9. However, if the parent is working and wants to drop the student off at 7:30, or the district bus, so by example, the Radnor bus would still pick our Radnor kids up at 7 o'clock for a 7:30 drop-off. They wouldn't care if that kid was a 9th grader, respectfully, and that's fine, starting at 9 o'clock. But we tried to follow, we're a research-based school, so we tried to follow all the research, including the sleep research. So we made that change for the upper school kids.
So then, getting back to the original question, how many students take the bus? How many students are dropped off by car?
Of the 71 students, about 35 took a bus this year. So it's multiple kids on the same bus.
Thank you.
Were those Marple Township School District buses?
Well, I
Or
have a
Radnor.
Marple bus,
Yeah.
a Radnor bus, a Southeast Delco bus, 2 Philadelphia buses, one Lower Merion bus, one Springfield's Delaware County bus. So the buses follow just the normal 10-mile rule.
On the admission question, you mentioned 70-something this past year, and earlier you mentioned 100 and 110. So that's an aspiration for an expected enrollment for the next year. And to the extent admissions went well, what do you anticipate as the top-end student population in the space that you're proposing to rent from Carroll?
The statistical population for this is very small. So to meet criteria to be a gifted student, it's around 2.5 out of 100 kids. So our school will always be small, hopefully mighty, but small. In my grandest vision, we'd have around 275 kids as a fully operational school.
And would a school of that size fit in the space that you're looking to lease from Carroll?
Very easily.
No other questions?
Thank you.
I have no further comments or remarks.
Any other questions from the board? From
If
the
I may,
solicitor?
Counsel, are there any restrictions in the lease with respect to the number of students or anything that would relate to that?
I do not believe so. But the school is, as Melissa just said, restricted by its nature. It's pulling gifted students, which is a high bar.
No, I understand, and the facilities are what they are, but I just wanted to see whether or not there was anything in the lease.
No, not to my knowledge.
And just one clarification on the lease itself. I'm assuming that the portions of the lease that have been redacted because they reflect business terms or other issues that are not germane to the consideration of this board in the consideration of your application.
That is correct.
Are there any members of the public who would like to comment on this application? Okay.
And sir, I'll swear you in. If you raise your right hand, you swear yourself to nothing but the truth.
Yes, I do.
And state your full name.
Douglas Grant,
Spell
D-O-U-G-L-A-S-G-R-A-N-T. Good evening. My name is Doug Grant. I live at 135 Summit Terrace in Bryn Mawr. I'm a single father to Rory, an eighth grader in the Grayson School. Rory has attended the Grayson School since 2016. In that time, I have lost Heather, my wife of 20 years, and the mother of Rory. She was able to see Rory start his academic career at Grayson. Tragically, she was not able to see him complete his first year there. She was able to talk to him about his excitement of being able to attend Grayson. During the first week of his new school, he found an interesting object lying in the playground grass. As he was inspecting it, a teacher came along and asked him about his find. Expecting to be told to dispose of the object before re-entering the building, Roy dismissed it and said it was only something he found on the ground. What happened next took Rory completely by surprise. The teacher suggested he bring his new find to his science class later that day so that he and Rory could put it under a microscope for further examination. It turned out that Rory had found his first cocoon. This blew Rory away and has set the tone for his career at the Grayson School. While Radnor has the best school system in the state, it was just not working for my son. I wish it was, it just wasn't. He was becoming disengaged, checked out, and floundering a bit as he headed toward middle school. To be honest, I was scared for his next step in his life, not in an anxious way, as most people are, as their children are headed to middle school. This was, I might lose him, scared. He didn't have access to his peers and was not coming anywhere close to meeting his potential. He was losing interest in school because he felt he was not learning anything new. I get it. Gifted kids are different. Some get by with the current program. Many, like Rory, need a full day of gifted programming. In the short 3 years since Rory has started Grayson, I've seen my son come back to life and find his passions. In addition to excelling in academics, he is a fierce ultimate Frisbee player and a multi-award winning First Lego League teammate. I've seen him harness his innate curiosity, inventiveness, creativity, and his sense of justice. Roy's teachers recognize him as a classroom leader who is as comfortable communicating with adults as he is with his peers, and who often brings great insight and dedication to his studies. He is a loyal friend, never afraid to stand up for someone who's been wronged, and always ready with a word or joke of encouragement to diffuse the lingering tension. He has truly found his place at Grayson, whether in the classroom or on the playing field. I cannot imagine him thriving as much anywhere else. The Grayson School will be a great addition to the Radnor Township, And as a township resident, I fully support the school's plan and encourages the board to approve the application. I'm a proud Radnor parent, and thank you for hearing me tonight.
Thank you, Mr. Grant. Anyone else?
Yeah. Okay. I do. It's H. Elizabeth Braun, B-R-A-U-N. Good evening. Thank you so much for allowing me this opportunity to speak with you very briefly. As I said, my name's Liz Braun. My husband is here with me tonight. We are actually relatively new residents of Radnor Township. We recently moved to 217 Williams Road, specifically to be closer to the Grayson School. Our son started there 2 years ago, and we have been living in the Swarthmore media area, but really wanted our son to not only have an amazing school community experience, but we wanted him to be part of the town where the school would be. So we feel thrilled and are loving being a part of this great area. So as I said, my son started at Grayson 2 years ago, and there are many parallels in our stories. My son had an excellent education at Swarthmore Rutledge School. It's a fantastic school, but it was not the right school for him. He would come home, he's a very bright kid. He would come home every day from school, and I'd say, "How was school today?" And he would say, "Fine." I would say, "Did you learn anything?" He would say, "Not really." And so he sat there, and he got by basically by reading books all day. He's a voracious reader. He will read anything and everything. And we had to go to meetings at the school because my son was getting in trouble for reading. And I understood, like, he would leave his desk and just go where all the books were. And when we first heard about the Grayson School, I was intrigued. And when I met with Melissa and heard about her vision, I thought this is a real possibility. And when my son started there, he not only reads books now, but he is fully engaged. He comes home every day and tells me about all the new things that he's learning. He has really grown, not only intellectually, but personally. The values of the school, I think, are very much in keeping with the values of the town in terms of really wanting to raise good citizens who are engaged, who think about how to make the world a better place, who want to be engaged in the community. And so I would just really encourage you strongly to accept the school's application. You know, I really believe that this is going to be a fantastic asset for the area. And I think that it'll be exciting to see both the school and the town grow together. I think there's some opportunities for some wonderful partnerships as the school continues to grow. So thank you for your time. I appreciate it.
Thank you.
Sorry. I do.
You do.
Jill Williford Werman.
Scott Eric Werman.
Okay, JILLWILLIFORD WURMAN.
SCOTTERICWURMAN.
Good evening. My husband and I have been residents of Radnor for 11 and a half years. Strangely, we have never been inside this building. Tonight I realized I've parked in the parking lot 40,000 times because I've spent a lot of quality time on your baseball field. But those days are past. Little League is gone. We don't do that anymore. I'm here to support the Grayson School tonight because I know personally what an amazing place Grayson is. Our daughter, Piper, is going to be a 7th grader, which is a horrifying thing to say out loud. And she really has benefited from going to that school, and it's going to be a remarkable benefit to our township, I think, to have it here, to boast of a school that has a nationwide reputation and, in fact, an international reputation for its exceptional gifted education that it offers to its students. It's a unique place. The work they do is groundbreaking. It is being recognized as such by scholars in the field, as well as testimonials like you heard from parents. We, too, share that experience where we had a child who had a difficult time being served in the school she was going to.
now that she has gone to Grayson, there are things that she can do that are just not possible in typical school environments, even though Radnor has extraordinary schools, which is why we live here. She, for example, there were 17 students in the entire grade, and that was 5 separate levels of math classes that were being provided to those students, some of them one-on-one, because that's what the kid was capable of doing. She loves math, and that's great, especially for a girl to hear that math is great. Go team. And one of the things that Grayson was able to do is at the beginning of the school year, she was in a pre-algebra class with 5 other kids, so there's 6 kids in her class. And the teacher saw that the kids were just eating the math. Like they were just chewing on it. They're so into it that the pre-algebra class turned into a pre-algebra and algebra class. And next year it's going to be a geometry class. They did 2 years of math in 1 year because they could do that. In fact, at the end of school this year, her class literally discovered something new in math that nobody has ever found. And the math teacher looked it up on the interwebs, and in fact, it is not out there anywhere, and he is learning how to publish what they've discovered, this bunch of 11 and 10, and I guess there's 12-year-olds in there too. So that is an extraordinary educational opportunity that really does not exist anywhere else, and I'm blessed to have the opportunity to have our daughter have that kind of space where she can be who she really is. I know you'll be shocked to hear that on the baseball field, it's not typical for somebody to be holding onto a book and reading for the entire time, but that's what she did for all of the baseball seasons she had to survive to live through her brother's childhood. So I don't think she ever actually watched a baseball game. I think she read all of the Chronicles of Narnia one season, and then there was another season where so she's an unusual child, and in any other environment, she would look like a weird child. And in Grayson, she doesn't look like a weird child. She looks like one of the Grayson kids. You should understand that we really do feel like Radnor has a great school system. That's why we bought our house where we did, even though we had to scrape money together between the couch cushions to be able to afford it when we moved here. But this school is different, and it's a specialty school for a specialized population. I kind of feel like it's like having a great, well-recognized hospital in your town, but then the Mayo Clinic decides to build a clinic in your town. Not everybody needs the Mayo Clinic, but the people who really need the Mayo Clinic really need the Mayo Clinic. And the community where the Mayo Clinic shows up is all the better for its having arrived. So as a Grayson mom and a Radnor taxpayer, I encourage the board to support their application. Thank you very much.
Thank you. If there's no one else, okay. Council, anything else that you'd want the board to consider, or just move your exhibits
Yeah, I have nothing further. I'd just like to move my exhibits.
without exception?
Thank you.
Let's start with a motion, if anyone cares to offer one. That's right, you're getting this one.
I move that we grant the relief sought under 280-101 Prin 1 as as a change in use. I'll stop there. So,
Second.
Okay, let's talk about that. Bill?
yeah, I mean, I don't have strong feel. I understand the legal argument about the constitutionality of the provision here. I don't think it's our job to interpret what the commissioners have done. So I think we're going under the assumption that the 280-101 is enforceable. And then the question is it a change in use or an expansion in use? I don't feel caught up on that technical point. Practically speaking, I would support the relief because I think bottom line is the school has historically been used for many, many students, more than what Carroll is likely to be using it for in the near and medium future. And the incremental number of students still leaves us below that number. There's no evidence that there's going to be any detrimental impact to the community. So I would be in support.
Okay, no other discussion? Let's call the vote. All in favor of granting the relief sought under Section 280-101A1 of the zoning code, please indicate by saying aye. Aye. All opposed? Not opposed? Good luck. We turn now to, we turn now to Appeal 3029, the applicant, Villanova University, property located at 800 East Lancaster Avenue and zoned PI. Applicant seeks to modify the conditions imposed by the prior decision of the Zoning Hearing Board in Appeal 1554, dated November 20, 1980, regarding a grant of relief by the Zoning Hearing Board from the height requirements for light standards at the Villanova Football Stadium. Counsel?
Thank you. Nick Cornelia, representing the applicant, Villanova University. I have marked as additional exhibits, and I'll hand them up to the board. The first exhibit, which has been marked as A10, is a settlement agreement and stipulation between the Township and Villanova regarding the use of the lights. And then we have an exhibit, a CV for Bob Zoller, who'll be testifying, a consultant for Musco Lighting, who will be testifying this evening as to the lights that Villanova is proposing to install on the site. And I've also prepared a new updated list of exhibits, and I'll hand these up to the board so that you have them. I'll hand one to Mr. Nelson as well.
Peter, while Nick is doing that, do you want to just enter your appearance?
Peter Nelson on behalf of Radnor Township. Obviously, the township has entered into an agreement with Villanova. I'm here on behalf of the township in support of this agreement and ask that the board accept the agreement and make the agreement part of their decision.
Thanks. Nick, at the risk of asking you to truncate the tortured history of how we find ourselves to this place, this appeal was originally submitted in November?
I
October?
think the first listing may have been December,
Okay.
but it may have been December. It was around, it was in 2018. I know that, toward the end of 2018.
And as everyone knows, it has been continued for a number of meetings because discussions were ongoing, because we didn't want to get in the way of that. Parties were amenable to that, but now I think we're going to decide this thing, right?
And actually, Nick, if you could give a brief history.
Sure.
Not of
Yeah.
you coming before us, but why we're here today.
Yeah, okay, I will.
Yeah,
Yeah, I
thanks.
anticipated you'd be asking that. Back in 1980, Villanova received relief from the height requirement of the township to install lights at the stadium. Up to that time, the stadium did not have lights. The requirement of the township on the height limitation, the township code at that time was 50 feet. Villanova was installing the lights at 100 feet. They were granted a variance at that time. You see in the file that in 2006, there was a resolution on a different project at Villanova where the Board of Commissioners had a condition that the lights were supposed to be only used at a certain level. I believe it was after 10 o'clock and then turned off by 12 o'clock. Recently, within the last couple, probably last year, There was much discussion before the Board of Commissioners regarding what, if any, restrictions did Villanova have regarding the use of those lights. As a result of that, we went in, met with Mr. Kachansky. He kind of gave us an email as to what he saw was wrong with the lights in accordance with that 1980 order. We disagreed with that, and in fact appealed both the fact that that order was not conditioned on certain items, as well as asking for a change of circumstances if the order was in fact in existence and there were conditions on the order. Since that time, we entered into multiple discussions with the township, and to be quite fair, the township commissioners meet once, twice a month. I have a list of people that I have to go through with the agreement. We went back and forth on various drafts of the agreement, and eventually we reached what was approved by the Board of Commissioners, I believe it was last week. You'll notice that the settlement agreement indicates that the violation notice is being withdrawn. So what we're here this evening is proceeding on the change of circumstances, in that we are actually installing new lights in the stadium. And as a result, if you granted that by right, you couldn't condition it on anything. So obviously, we're asking for relief from the zoning board so that we can condition it based on the agreement that was reached between the township and Villanova. Okay.
Can I ask a question? I have a question. So the 1980 relief that was granted, did that, in your opinion, did that include anything to do with the actual fixture, or was that just the height of the pole?
Really, it was the height of the pole. You know, the height of the pole, and it did say the lights, you'll see the lights are so different than with, state-of-the-art lights now. And that's really where it came down to, is that our belief was that the order dealt with the height of the fixture and not conditions of the usage of the lights. The township disagreed, and as a result, this started, and a notice was issued saying to conform to the 1980 order, even though we contend that there are no conditions on that 1980 order. But we want to resolve this. We know it's a big concern with the neighbors and with the township, and we're hopeful that the zoning board would approve this with the conditions that have been agreed to here. Sure. Just as I mentioned in opening, and just so the board knows, and I'm sure Mr. Nelson doesn't disagree, the issue regarding the violation notice has now been removed. The township has removed the violation notice, so obviously we don't have to consider that here this evening. And actually, for the first witness, I want to bring up Bob Zoller from Musco Lighting.
I do. Robert G. Zoller, Z, last letter of the alphabet, O-E-L-L-E-R.
And Bob, what is your profession?
I'm a technical consultant for Musco Sports Lighting.
What is your background?
My background is I have a master's and bachelor's degree in physics. I've been involved in lighting for over 25 years. I have 5 publications in the Journals of Applied Optics, and I've been involved with sports lighting for the past 20 years. I've been qualified as a lighting expert in 7 states, and I've been involved in over 3,000 lighting projects. I'm normally called upon by over 100 consulting firms throughout the northeastern United States to provide lighting solutions for their applications.
I've marked as A11, a CV of your qualifications. Is that true and accurate?
Yes, it is.
And I noticed on there you actually were qualified as an expert in several jurisdictions, many in New Jersey, and actually many locally in Pennsylvania as well.
Yes.
Tell us a little bit about Musco, the company itself.
Musco Lighting has been involved in sports lighting for 44 years, and that is basically the thrust of the company. We are currently the leader internationally in sports lighting. Any Olympics that you've seen since 1982, Musco's been involved. Musco has had the privilege of working on with four local projects. We've had the ability to do 2 fields at Radnor High School. We did the soccer field at Cabrini College. We did 2 fields at YSC, and then we also did the Memorial Park field for Agnes Irwin.
And has Musco now been engaged by Villanova to install lights at the Villanova Stadium?
Yes.
And were you provided with design parameters as set forth in Exhibit A10, which is a settlement agreement that's been entered into by Radnor and Villanova University?
Yes.
And as a result of those design specifications, did you come up with a design for the lights at Villanova?
Yes.
And if you will, if you can go through the board, I've marked before you, you're going to see, he's going to do it on computer, but A12 through A29 actually are the exhibits themselves when he refers to them. I asked Bob to refer to the exhibits if he can.
Oh, we could do it on the computer.
You want to do them on computer? Yeah, do them on the computer. I think it'll be
We could
better.
actually do it here if they can make it big enough. We can just do it right here if you want.
Is the board okay with that? If we do them right?
Is that okay? Is that
Sure.
acceptable to the board? Very good.
So first, you've marked as A12. We've marked, and can you just tell, is that's just
Yes.
a cover sheet?
Exhibit A12 is just the cover sheet, just shows a variety of applications for LED lighting, and that is basically the purpose for Exhibit A12.
Okay, you can proceed.
Okay. Exhibit A13 is a plan view of the Villanova Stadium. Currently, the top of the page would be north, the bottom of the page would be south, so obviously right would be east, left would be west. The stadium on the north stands, there are currently 3 lighting poles that are located behind the north stands, and they're shown on the drawing. There's one approximately the 5-yard line, one at approximately the 50-yard line, and one at the opposite end of the field on the 5-yard line. On the south side of the field behind the south stands, as indicated in the exhibit, there are also 3 poles. Again, there is one pole at around the 5-yard line. There is one pole that's offset from the 50-yard line because of the press box structure. And then the 6th pole is located by the 5-yard line as well. As has already been indicated, all 6 poles are 100 feet in height. I'd like to move to Exhibit A14.
Bob, just quickly on that 100-foot
Sure.
height limit, is there any significance as to 100 feet?
Yes.
And could you tell?
Sure.
What that is?
Typically, pole height is determined by the distance that the lighting pole has to be from the field in order to achieve proper both horizontal and vertical light levels. The further the pole is located away from the field, the taller the pole you need to provide proper vertical lighting to the field as well as proper horizontal lighting to the field. Based upon the setbacks and distance from the poles from the center of the field, the 100-foot pole provides the adequate mounting height to ensure that we have proper aiming angles for playability for both vertical and horizontal light levels on the field. Moving to Exhibit A14. In 1997, Musco Lighting installed technology called SC2, Sports Cluster 2. Here's a picture on the left side of the exhibit of the existing Musco lighting fixture. In 1997, and actually prior to 1997, sports lighting fixtures basically consisted of a parabolic reflector that was a floodlight that would just project light out, and the purpose was to get as much light as you can, as far as you can, to illuminate the field that you were going to utilize. With this technology, which was state-of-the-art in 1997, the bottom of the lighting fixture has an internal insert. You can see it's a 6-pieced faceted louver that's inside the fixture, and that louver helped reduce spill by 65%, and it helped add 25% more light efficiency onto the field. So at that time, that was state-of-the-art. The picture on the right side of the exhibit shows the current pole. There are currently 18 of these lighting fixtures atop of each one of the 6 lighting poles currently at the stadium.
At the risk of getting a bit into the weeds, you used the term spill.
Yes.
Could you explain what that is?
Okay. Spill light, there's really three categories of spill light. There's actual light spillage, that's light that proceeds beyond the area that you're trying to illuminate. There's sky glow, that is the light that gets projected up into the sky, and we can see with unshielded fixtures for long distances, we see the sky all lit up and illuminated. And then there's also glare. Glare causes discomfort. It can be disabling from tasks because of the brightness. The luminous intensity is what the brightness is emitted from the source.
Thank you.
Moving to Exhibit A15, we have the proposed lighting fixture. The proposed lighting technology is Musco TLC for Total Light Control LED. This lighting fixture is the first sports lighting fixture that is a full cutoff fixture. By that I mean there is no light projected above 90 degrees to nadir, or no light projected above the horizontal portion of the fixture. The second important part of this technology is that the light source itself is tucked up inside of the fixture. If you look at the picture, you can see some of the bottom row of the LEDs, and this is an LED fixture. You can see the LEDs going across at the bottom, and the rest of the LEDs are all tucked up inside the shield. So we do not have a situation where the glare or the view of the light source is an issue anymore, because now we've completely shielded that. Moving to Exhibit A16. Exhibit A16 shows the quantity of fixtures that's proposed. Now, the picture itself is generic. It just shows the fixtures as round, just to indicate the number of fixtures. Keeping in mind the fact that I showed you the earlier exhibit that there's 18 lights currently on each pole. Exhibit A16 is the south side poles. So what we are proposing is for the southeast pole, we're going to go from 18 lighting fixtures on the top of the pole down to 10. For the center pole, we're going to go from 18 lighting fixtures to 8. For the southwest pole, we're going to go from 18 fixtures down to 10 as well. And then Exhibit A17 shows the north side poles, whereas the northeast pole is going to go from 18 down to 10. The north center pole is going from 18 down to 8. And the northwest pole is going from 18 down to 10. So there's a significant reduction of the fixtures. And that's because of the efficiency now of the lighting. Light that was lost due to glare, due to spillage, due to sky glow, is now being directed onto the field, hence the reduction in terms of the amount of lights that are needed to achieve the same basic lighting levels on the field.
What's the technical reason for the variation in numbers of lights at the lower level, north to south? The one I noticed the one middle pole is empty on the. You have 3, then empty, then 3, and on the other direction is 2
Yes, I'm
each.
sorry, I didn't mention those. The lower fixtures that are mounted on the poles, because we have full cutoff fixtures now that we're illuminating the field, there is a plane over the field, that there's no light. And what we have to do is we have to make sure that there's proper vertical illumination of the ball, the object, as it would be flying, say, a football that's being punted over the field. We can't have a situation where that ball actually goes over the light and gets lost, because we create a safety and a playability problem. So what we have is what are called ball tracker fixtures. They're very low wattage, only 500 watts, fixtures lower on the pole that project just a small amount of light upward above the field, so that the ball, the object, no matter what height it travels, it's never out of view for the athletes that are participating in the field. Now, we don't have any ball trackers on the south central field, because that pole is set right next to the tall press box, right behind the tall stadium. So basically, it doesn't make sense for us to have any ball trackers there, because they wouldn't project. They wouldn't. I must have talked too much. word out.
You can use this.
Okay.
And this lower level fixture, I take it the distance that the light from those fixtures will travel is shorter than those that are set at the higher level?
That's correct. That's correct. And they serve the purpose. You're dealing with, when you're looking up into the sky, you're dealing with an issue of contrast. So if I'm looking at, be it a football with 2 white rings at the end of the football, maybe I'm looking at a soccer ball, which is a white ball, lacrosse, which is a white ball, because you're against a black sky, you only need a small fraction of light just to be able to see that object. You don't need much light. When you're down in the field and you have the stadium surrounding you and you have all the different colors of the people and all of the different things that would draw your attention away, you've got to have, in the speed of the sport, you've got to have more illumination, higher level of illumination.
And that distance from ground to those mid-level, you have it here, it's a little hard to read. 30-something feet?
Correct. Nominal, 30 feet.
Okay. Nominal, you mean approximate?
Yes. Give or take a foot or two. Thank you. We'll go to Exhibit A18. I'm sorry, I have this problem. I keep wanting to move it closer to me. Exhibit A18 is the lighting plan for the field. Basically, what we're doing is, thank you. What we've done is we've shown that the illumination, the highest level of illumination for the field, this is the grid as would be required by the Illumination Engineering Society. And to meet both the Illumination Engineering Society and the NCAA lighting requirements, and to be consistent with the lighting that's currently on the field, we have a maintained average of 75-foot candles, which would be the highest level of lighting on the field. The field is capable of dimming, and so the lights can be dimmed down to 50-foot candles, and then there's also a much lower light level that the field could be dimmed down to as well. So basically, the illumination level is staying roughly the same as what we have on the field currently, or actually the design level for the field that originally was designed for is what we're still lighting the field to. Exhibit A19, and the reason I'm showing this is because this is for the track. There is no illumination proposed or part of this application to light the track for competition light levels. There's not going to be any nighttime track competition. What there is we have low levels of illumination on the track bends so that there's enough safe light out in those areas for anyone that would be out in that area, but there is no lighting for a competitive track. So that's why this exhibit is included in the package. Moving along to Exhibit A20. Now, it was pointed out to us that the most important part of this project is to maximize our reduction of spill light, maximize the impact of the lighting system to the adjacent properties that surround the field. And we have a good track record with the township because we did do the lighting at Agnes Irwin Field. I was involved with that, and I remember there was a lot of concern about what the light impact would be from Agnes Irwin Field. And when it was installed, we checked, we met all of the criteria that was presented to the board, and from my understanding, there was no complaints from any of the neighbors based upon that application. That is one level of technology prior to the level of technology that we have for this project. And what Exhibit A20 shows is what we do to look at the light depreciation is we do what we call a blanket grid. We have, at every 30 feet, we generate a light value of what that light spillage is going to be. And it is a small drawing. I apologize for that. But if you look very closely, it's not very far from the field that the light levels all go to 0.0, and this grid is showing horizontal foot candles. To get a better view of that, the next exhibit, which is A21, has those horizontal foot candles overlaid on a Google image. So as you could see, if you look around outside the field, well before you would reach any of the adjacent residence properties, the horizontal foot candles go to 0.0. Now, in line with reducing the impact to the adjacent residents, we did a study, and Exhibit A22, what we did, because Musco had supplied the lighting system in 1997, we were able to go back and we were able to generate what the spill values would be along the property line. And the first property line we're looking at is the eastern property line, and that is shown as the green line on the drawing to the left of the wording. And what we did was we looked at three different things. We looked at horizontal foot candles. Now, horizontal foot candles is the standard method of measurement. You take your light meter, you hold the meter parallel to the ground, and you measure the light that's incident on the meter. That's the standard because anyone can take a horizontal light meter and get reproducible or repeatable results. We take it a step further now, and what we do is we take the meter and we hold the meter vertically back toward the lights. Because truly, the light is traveling more so vertically than horizontally when you're looking beyond the area that you're illuminating. So we're going to take a measurement of what the light would be vertically, and what we do is to establish a standard for that measurement. We take the vertical meter and we move it around till we get the highest value. So it's the worst case, if you would, of what the vertical light would be at the location where we generate the value. And the last thing we're going to generate is the luminous intensity and candle power. That's the brightness that's incident at the different areas along that property line. So if we look at that existing Musco lighting technology along the eastern property line, the highest maximum horizontal foot candle value is 0.4. The highest or the maximum vertical foot candle value is 1.9 foot candles, and the highest level of luminous intensity in candela is 27,430. So what does that mean? So first of all, the candela, about 1,000 candela and less would be the amount of brightness you would get from a porch light. 12,000 candela to 15,000 candela is what you would see from a low beam headlight. You're traveling along, you have that amount of brightness coming towards you. It's not totally disabling, but if those lights aren't adjusted properly, it could be a problem, and that would be because of the higher luminous intensity. A high beam headlight is 30,000 to 50,000 candela. So in this case, we have almost a high beam headlight worth of luminous intensity at the eastern property line with that existing lighting.
Do these measurements vary at all given atmospheric conditions? For instance, if there's heavy cloud cover or misty winter weather or something like that, do those atmospheric conditions affect what these measurements might be?
They'll affect it some. They might reduce them some in terms of the spillage at the property line. They will enhance sky glow. They make the sky glow become very noticeable, the higher levels of humidity in the light. And that's something you see anytime you have an unshielded fixture and you have high humidity or you have any kind of mist or anything of that nature, an atmospheric condition, the light scatters. And so it becomes a much bigger area and a bigger illuminated area. Here at a distance, however, the values could come down because of the greater amount of scattering. So it actually comes down a little bit when we're talking about measuring at a distance, but up close, on the field, and above the field, it becomes worse. It becomes much more noticeable. Again, more scattering of the light by the particles of water that are in the atmosphere.
Somewhat related question.
Sure.
Would the measurements differ to the extent there was a topographical distinction? So, for example, if you measured at point 1 and then you moved 20 feet away, but 20 feet away was 30 feet higher, how would that impact the measurements?
Topographically, the higher you would be, the less the value would be because you're moving higher up in the beam. The higher up you're going in the beam, the less the value of the lighting is, considering you're projecting the light down onto the field. So the higher you go, the less candela you're going to have, the less spillage you would have higher. You have the opposite if you're going lower. Now with these values, the way we calculate them, it's a good point, is the fact that we make an assumption in these values that there's nothing between the light source and the point that we're measuring. So we don't count structures, we don't count grandstands, we don't count foliage, nothing. So these values are generated at the property line, assuming there's absolutely nothing from that light, from those lighting poles to that point. We just don't know what's in between. Things can change, so we always take worst case. This is assuming there's nothing there. Exhibit A23, this is where we'll be with the proposed lighting. Along the eastern property line, the maximum horizontal foot candles will now be 0.0. The maximum vertical foot candles will now be 0.0. And the luminous intensity in candela, again, with nothing in the way, nothing blocking, and this is at one point where it's the maximum, is 673 candela. So we're going from a high beam headlight currently to a porch light. And if there's anything in between that point and the field, there'll be nothing there.
I'm sorry. A22, the measurements, are those actual measurements or were they just computer generated?
Those were design measurements based upon the original design, which was worst case, because that was going to be the brightest, and that would be repeated if the whole stadium was relamped, you come back up again with light levels. So we decided to take the worst case just to make sure it was properly and adequately shown.
Those are not field measurements?
No, these are design measurements. Exhibit A24, we looked at the southern property line. Now, the southern property line is what we've tested, or what we've generated computer values along, is the central portion of the roadway of Lancaster Avenue. We utilize that because our understanding that that is where the property line is. And we went all the way along Lancaster Avenue, even though immediately across from the stadium, Villanova has additional fields. That's really their property. But the residents start pretty much above the R in the word southern, or the H-E-R in the word southern. That's approximately where the residential properties start. And then they move to the east from that point. In the opposite direction, moving westward, that is where Villanova has other fields on the opposite side of Lancaster Avenue. Going back to the existing technology, we have 1 foot candle maximum horizontal, 4.5 maximum vertical, and we have 37,428 candela along the southern property line. And A25, exhibit A25, once again, we'll have 0 maximum horizontal foot candles, 0.1 maximum vertical foot candles, and I want to caveat that. The 0.1 shows up in the area between the stadium and the existing Villanova fields on the opposite side of Lancaster Avenue. Where the residences are from the east, moving eastward from the goal, if you would, from that area, there are 0.0s vertically as well. And once again, we have now 2,179 luminous intensity candela. Where the residents are, we're down to about 1,000. So that is it's approximately about a 98% reduction in impact from the existing lights to the new lights. And exhibit A26, it just basically puts it all on one page to show you the difference. Exhibit A27, the reason I have this in here, the picture on the left side of the exhibit shows what the Musco lights will look like when you're looking at the lights from the distance. You could see, first of all, that there's no up light above the fixture. You don't see any glare going upward. Because of it being the full cutoff fixture, we're eliminating that sky glow problem. We're eliminating that bright aura that most of the neighbors have seen from the existing lights. Secondly, because we're hiding the lighting fixtures themselves, we're shielding them, you don't see the glare looking directly at the lighting fixtures as well. The picture on the photo on the right side is another LED lighting source. And I just wanted to put it in there because the idea is not just because we're using an LED light source, though an LED light source, because of its very nature and the ability to add proper optics within a fixture to direct the light, is better than having a metal halide lamp that's directing light everywhere. But it's the technology that's involved in the reflector, that housing that directs the light and projects the light, that makes a difference. So the left is the proposed technology, and the right photograph is another LED technology, illuminating a field to the same lighting level. So it's not just LED, it's the proper shielding on the fixtures. A before and after example, here is a project called Notre Dame Prep in Scottsdale, Arizona. The upper left picture, you could see unshielded fixtures, glare, and the picture on the right, again, has been retrofitted with the proposed technology. And then the exhibit 829 is a little bit closer to home here. Is the Chamonix High School in Langhorne, Pennsylvania. The photo on the left side of the page illustrates a technology very similar to the technology that is currently illuminating the Villanova field. You can see that the lighting on that project is only to illuminate the field, not the track, not anything else. You could see lighting going beyond the track. You can actually see in the left corner of that photograph illumination on the water tower that's away from the field. From that lighting, you can see the grandstands are bright as day. Looking at the picture on the right, which was the retrofitted with the Musco lighting, you can see now the water tower has gone away. There's basically no light in the track on the bends. There's very little light in the bleachers. There's just sufficient lighting for people to egress, go in and out of the bleachers, and the reduction in glare, it was approximately 95% reduction in glare on that project. Lastly, what comes along with this is a wireless control system. The wireless control system gives the ability to control the lights and turn them on and off, so it's not a function of a person going and turning switches off and turning on and off lights and being responsible for that. It's set via computer through a wireless system, so when the lights are supposed to be off, the lights will be off regardless. You don't have to worry about somebody taking care of them. It's taken care of by the wireless system.
And what about dimmability?
Yes, it has 3 levels of dimming. So basically it's the same situation. You could schedule the light level that you want through the wireless system as well. And with the LEDs, you can switch right from one to the other. It's not like the old metal halide lamps where they go off, you gotta wait 20 minutes for them to come back on.
And I'm assuming the calculations that you've presented this evening are based on the highest intensity light of the lights that are proposed for installation?
That is correct.
On the dimming question, A18 provides some measurements across the field at certain points. Give us a sense of the two dimming options, what the range of values would be as they step down.
The range can't exceed 2 to 1. So that means that the highest value cannot be more than twice the lowest value.
Okay,
So,
let me rephrase my question then. In the middle of the field here, it's about 76, 77, 75.
correct.
You have 2 lower levels. At each of those lower levels, what are the approximate candle levels?
You might have at the
No,
50
so are you telling me that it's based upon what the university asked for, or is it a fixed part of your system?
It's a fixed part of the system.
Okay.
So when they turn it on for the highest level, which is this level right here, you're going to have an average over these 72 grid points. Some points will be lower, some points will be a little higher, so that this way the average of all of those 72 points is going to be 75-foot candles.
Okay.
Now, they hit a switch and it dims down. Now the average is going to be 50-foot candles over the entirety of the field. And then there's going to be one additional level, which is lower. I believe it's going to be about 20% of the lighting level on the field.
So you're 20%.
So you're talking about 15-foot candles or
Fine.
so?
Thank you.
Any other questions?
One question, Nick can tell us whether it's this witness or otherwise. I'm curious of the nature of the installation process. I mean, it's not, you go from the October 14th with the old lights to October 15th with the new lights. What is the, how long does it take?
Sure, maybe Bob again. Okay.
I can ask that. We're not making any changes to the lighting poles, the foundations, the poles stay, the foundations stay. So basically, it takes 6 to 8 weeks, probably 8 weeks, to manufacture the lighting equipment and to deliver the lighting equipment to the site. It may take 2 weeks, 3 weeks for an electrical contractor to take down the existing lights off of the pole and put the new lights onto the tops of the poles.
I believe the intent was to have these done by the time the semester, I don't know if Chris. Okay, Chris could be the next witness, he can testify to it.
Okay, thank you.
Thank you very much.
Thanks, Bob. Chris.
Do. Christopher Kowalski, Kovolski.
And Chris, what is your position with Villanova?
I am the Assistant Vice President for Government Relations and External Affairs.
And I've already marked and handed up to the board Exhibit A10, which is the settlement agreement entered into by Villanova and the Township.
Correct.
And that was executed by Villanova and the Township as well.
Correct.
I'm sorry, Norma. And that agreement was executed by the Township and Villanova as well.
Correct.
And that agreement also contains 3 exhibits, and they're the exhibits that were agreed to by the parties as well.
Correct.
Just going through some of the documents. First, I'm going to show you what's been marked as A1. And A1 is the application, correct?
Correct.
A2 is a copy of the deed for this premises, and when did Villanova acquire this property?
1842.
And when was the stadium constructed?
1927.
And was it not until 1980 or 81 that the stadium actually had lights?
Correct.
Showing you as A3 is just like an overview aerial of the stadium and the surrounding properties.
Correct.
And A4, you heard us mention this before. This is appeal number 1554 from 1980, the zoning board regarding the height of the light standards for the stadium.
Correct.
And A5 is just the zoning code at that time indicating that the requirement was 50 feet height.
Correct.
And A6 is resolution 2006-05, and that has in resolution number 26 regarding when the stadium lights were going to be turned on and off.
Correct.
And both the zoning opinion and the resolution were part of this package and the agreement.
Correct.
And kind of that's the dispute between the township is which one's applicable and which one's not applicable. And
Correct.
all right. A7. Again, remember, many of these exhibits were prepared at the beginning of this process when we're looking at different matters here.
They've yellowed over time.
Yeah,
But
right,
yes, we recall that.
I've lived this for 7 months or 8 months too, so longer, I don't know. A7, this is just showing distance from property lines from the various closest light standards, correct?
To the adjacent properties, yes.
Right. Some of them are the property lines, some of them seem to appear to be the homes themselves.
Correct. Because many of the actual homes the university owns, so we want it to be as comprehensive as possible.
But actually in the agreement, we're agreeing that there'll be 0-foot candles at the end of the institutionally zoned land, even if Villanova owns property
Correct.
in the residential area.
Correct.
I'm sorry.
Usually it's me, Norma. I'm glad it's Nick this time.
Okay. A8 and A9, these are just photographs, and these photographs represent the lights as they exist today.
Yes.
And when were these photographs taken?
Mid-November of last year, 2018.
And again, they're pretty consistent with what Mr. Moeller testified to, or Mr. Zoller testified to, as to the intensity of the lights.
We did not take measurements at this time. There are simply pictures of the light and the impact of the light at 100% power and 50% power.
Now, is there a need at Villanova for these lights?
Yes, this is the only lit playing field at Villanova, and it's used for both varsity sports, club sports, intramurals, recreational activities, both formal and informal, and it's used throughout the year.
How does Villanova use their current facilities? Is this just used by varsity sports, or is it used by others?
No, it's
as well?
used by our entire campus community. We do use it for special events, township events, community events, things of that nature. It's used like a traditional stadium would be. Certainly, our varsity sports are the primary tenants, and then other activities related to and associated with the university.
And also you have ROTC and intramurals and...
Correct. All those activities happen in there. ROTC trains in there.
I believe Mr. Martin had mentioned who's going to be using the stadium. Was that your question, Bill? I'm sorry.
No, you asked me installation.
Oh, installation. Okay, fine. All right.
Do you want me to answer that now? Since we brought it up.
Sure. Well, why don't we get through this first? Is there a need at the university regarding, or is there stress on the existing facilities at the university for intramurals and the like? I'm sorry. Okay.
There is a need for these kinds of facilities with these lights at the university.
Yeah, maybe that's the better way to do it. Yeah. Okay.
We know that there is a tremendous popularity in these kinds of activities that use the stadium. Our students come to campus as active young people, and they look to continue being active and increase their activity on a college campus. And we are trying to provide programs not just at varsity club and intramural levels, but a variety of recreational activities. Our resources from a facility standpoint are taxed, and with this being the only space that's lit, we want to be able to maximize it as much as we can to support the interests and needs of our students.
What's the timetable as far as installation of these lights if everything goes right and the zoning board approves our application? And
I believe in the agreement, it stated that the lights will be installed on or before October 15th of this year, and our goal is to exceed that as much as we can and get that to be as close to the beginning of the academic year as possible. As Mr. Zoller testified, there is lead time in the materials, but our intent is to proceed as quickly as we possibly can to get them in place. We do have home varsity football games that we want to be able to support with these lights. We as much as we're talking tonight about the impact, the very real impact on our neighbors, the lights that we have now are inadequate really from a standpoint, and you'll hear more about that from future testimony, but it is in our best interest as well as in the interest of this agreement to accelerate the timetable to install the lights.
that's all I have.
Questions from the board?
Yeah. So in terms of the list, the varsity club, intramural sports, ROTC training, Villanova events, special events. The settlement agreement has a carve-out where there's an agreement not to use the lights when the university's not in academic session except for special events or Villanova events. And Chris, maybe this is for you, or maybe it's for Nick. What is the definition of Villanova events and special events?
I believe the agreement doesn't really provide a definition, Bill, as to what are special events and what are Villanova events. Go ahead, I'll let Chris.
When we were having this conversation about the agreement, our desire was to be able to continue using the stadium in the manner that we use it now. We don't anticipate an increase in the scope or amount of events. Could that fluctuate on a year-to-year basis with a couple here and there? Yes. No more Hoops Mania concerts. I've already told you that. But using the stadium in the manner that we use it now, and we wanted flexibility to be able to continue to host those events and others that come up that meet that criteria.
And your read is that would also include perhaps leasing out to other users of the facility? other athletic users?
Are you speaking about the language about professional sports teams?
Yeah.
Or that's happened in the past. I know from 2001 to 2003, the Philadelphia Charge women's professional soccer used the stadium, and from 2004 to 2006, the Philadelphia Barrage of the men's lacrosse league used the stadium. We have not had a professional tenant since then. Again, there'll be my colleague from athletics who can testify to that.
Question for the solicitor. Would a use by a professional sports team be a permitted accessory use or an incremental use that would require incremental relief from this board?
With respect to this variance on the height of the lights?
Among the potential areas of concern are the opportunities the lights may provide for much more intensive use of the stadium and the impact of that on the neighbors. And there is ambiguity about the university's intent regarding professional sports. And my question, the concern for that would vary. I mean, I haven't researched the point, but I would suggest that use of the stadium by a professional team is not accessory to the university's purpose. That use by a professional team is not a permitted use under the district, so they probably would require a variance. If they would require a variance, arguably there's less concern about that because there'd be another process for determining whether a lease to the XYZ professional team would be of impact on the community.
As you stated, I haven't researched it either, but I would agree. Based on what you're asking me right now, a professional use of the stadium, in my opinion, without having researched it, would be a different use. And I think that would require a variance.
Does counsel for the university have an opinion on that?
I probably have a different opinion on that, again, not having researched it, but the agreement, if there's a need for a variance for some type of use, the township's not waiving the right to enforce a variance if there was a use that was not permitted under the zoning code. The agreement does not provide for that.
Well,
We would hold that.
Yeah, why don't we go entirely around the horn? Peter, do you have any thoughts on whether the use by a professional team would be consistent with the rights that they're asking for now, or would that be something that you'd envision the township thinking took an additional approval?
But, I mean, it's a completely separate question, whether, that being said, as with everyone else, obviously, I didn't research this question. My only disagreement or comment on it would be, these uses were allowed prior. I don't believe zoning has changed since the prior professional teams played in Villanova Stadium.
Hold on. Isn't this covered by the district that was approved?
No, this is the other
Okay,
side.
well, even if it was covered previously, there'd be no vested rights because it would have been abandoned.
No, I'm just saying, I don't believe the zoning of covering the stadium has changed since the teams played there. So I assume at the time in the early aughts, when the professionals teams played there, the township at that time made a decision and determined whether or not they required a variance. I don't know if they received a variance back then, but if that's what the township determined back then, without doing further research, I'd continue to follow that same determination. Certainly, if Villanova decides to, has someone approach them and has a professional team that wants to play in their stadium, that's a question that my office would be addressing at that time. And if it doesn't meet, if we feel it doesn't meet the zoning, then yes, they absolutely would have to get a variance. And there's nothing in this agreement and nothing before you at this time that would somehow preclude or prevent the township from stating that the university would have to get a variance.
Thank you. A couple other questions. Earlier, and this is for you, Nick, right at the beginning, you made the comment that the violation notice, I think you said, had been dismissed. And I just, as a matter of clarity.
Withdrawn, I'm sorry, it was withdrawn,
Had,
yeah.
and you use past tense, had been withdrawn. Is it that it has been withdrawn, or that it's anticipated to be withdrawn in connection with the settlement and the
It
resolution
is
tonight?
being withdrawn.
Well,
It's being withdrawn as part of the, I'll read the term, go ahead.
I was waiting for my turn to do this, but the township officially withdraws the enforcement notice that was originally a part of this application.
And that's without regard to whether this settlement agreement gets approved tonight?
Correct, because the township already agreed to it itself.
Well, and it's probably important to note that we're not being asked to approve the settlement agreement. We're being asked to change conditions or introduce conditions to a prior zoning order in accordance with certain of the provisions that are set out in the settlement agreement. But I would also note that if we don't do that, the settlement agreement goes away. So one might suggest it might be premature to withdraw the enforcement notice until such time as some action is taken that doesn't then leave you without a current enforcement action. Just an observation.
Yeah, the only thing I would say to that, the agreement specifically states at the zoning hearing on the modification of appeal number 1554, the township shall withdraw any notice of violation to Villanova regarding appeal number 1554. So they would have to issue a new violation notice if that were the case. I mean, they're not waiving the right to forever withdraw a violation notice and not issue a new violation notice if for some reason this was not approved, but the current violation notice would be withdrawn.
And another question for Chris, and this follows up on the different categories of use and is related to impact on the community. Currently, for what categories of use is the PA system utilized?
I don't know that I have the answer to that. I don't.
Well, that's a real problem, because what you're bargaining for is essentially for the entire school year to keep the place open till 11. If you're going to have music playing through that PA system for the entertainment of the intramural kids running around, as much as 7 nights a week, 30 weeks a year, I think that's an outrageous suggestion.
I'm not suggesting that.
Because there's a light issue, and your consultant has put on pretty convincing evidence that the lights are going to be addressed in a way to minimize the impact to the community. The other areas where the community is impacted is traffic. And, we know the ROTC and the club sports, intramurals don't drive traffic. There's varsity, varsity is what it is. We've kind of touched on the pro sports issue, special events, et cetera. But there's noise. There's significant noise. And part of the analysis has to be if the granting of the relief, how the granting of the relief is going to affect, that's the two-part test. Is there a changing condition? Is there not an incremental problematic impact to the community? I'm concerned about that point. I'm particularly concerned about the point because, your agreement says the agreement's the agreement. There's no other representations other than what's in the agreement. And this whole thing was started because of representations made back in the early 80s, representations, allusions, references made in testimony, where when they were pointed to an enforcement action, counsel says, if it's not in the order, it doesn't count. So if it's not in the order, it doesn't count. If it's not in the agreement, it doesn't count. And now in essence, we're not getting any comfort, either formally or informally, regarding the university's intention to police the expanded use of the facility. I mean, I have some sympathy to the need to use the facility in a more extensive way. But it's got to come hand in glove with taking reasonable measures not to have excessive impact on the community. And that PA system has been a constant source of annoyance to many neighbors. From music being played for hours before and after events. I'm going to get off I've articulated my concern there.
I have no further questions for Chris.
I was hoping for a response to Mr. Martin's observation.
I
don't
think
know there
Dan
was a
Gaston,
question.
actually, the next witness is from athletics and intramural, so he can respond to that.
I think there was an answer given, that there's no expectation that there's going to be change in the use,
That's
the way
correct.
you've been historically been using it since 1980.
That's correct.
That was your testimony, right? Okay.
I have a question. So the 2006 ordinance, the cutoff time, or whatever word we want to use, was for 9 p.m.
No, that was where the foot candles got reduced, and the cutoff time was at midnight.
Okay. Thank you.
Okay. I better go on this side.
Yeah, go ahead. Do you have that?
Yes, ma'am. Dan Gaston, Gaston. Yes, ma'am.
Dan, what is your position at Villanova?
I am the Senior Associate Athletic Director. I oversee event facilities and a few of our sports teams there.
And tell us a little bit about your background.
I graduated from the University of Washington. I got my grad degree from Seattle U in sports administration. I worked at the University of Washington for 13 years, both in events and facilities there. I went to the University of South Dakota. Yes, it was cold there. I did that for 3 years, and I've been here for about a year now.
And in addition to intercollegiate sports, does the athletics department also manage intramurals and club sports?
We do. We have 24 intercollegiate sports. We have roughly 3,500 students that participate in rec sports. 30 clubs, about 1,100 students that participate in those clubs.
And is there currently at the university a deficit of athletic and recreational space?
There is. We are strapped for space, whether it be indoor or outdoor.
And is Villanova unique in that there's a collaboration between the students and the actual athletic teams as far as the use of space?
In my history, it doesn't happen very often where intercollegiate athletics and rec sports or intramurals use the same places. So having the stadium act as an intercollegiate competition field, an intramural field, ROTC, community, all those things typically doesn't happen at a Division I university. Not saying that it doesn't, it's just not a typical. It wasn't that way at Washington. There were separate fields for both. Different things were lit. Even at South Dakota, it was the same way. So
now, for school teams, what school teams or what school teams, intramurals, clubs would be using this stadium, that stadium light?
Division I football, track, not for the lights, but they use the stadium. Lacrosse, both men's and women's, and then we have a lot of rec club sports. So anything from ultimate frisbee, soccer. Different things like that, and it's mostly from those 6 to 10:30 timeframes because they have class and then they go to dinner, and then they want to do something. And so, when you have a rec program, those are when you have the 5-on-5 soccer tournaments. You have the basketball. You have that because it's after dinner time, and it's the time for them to do it. And it's typically Sunday through Thursday. Those are the times that we schedule those events.
How important are recreational activities for the students at the school?
Exit surveys say that they're really important. I think Chris alluded to it. The students are more and more active. I think sports in 1980 were different than they are now. We all know that, whether it's high school sports, whether it's collegiate sports. Our student athletes train year-round. Our football team's here now. They don't go home. They train. You have camps out there right now, and the lacrosse team's out there with the camps. So there's a lot going on still, even right now.
How much use does the intramurals get? How many people participate in intramurals?
Intramurals about 3,500.
And is it necessary to have all these recreational athletic events for the viability of the university?
Absolutely. It's important for the students to be part of a community, and they go out and you're in your dorm and you get 5 kids to go out and play your 5-on-5 soccer or your ultimate frisbee, and they make connections and they go and they do these things, and quite honestly, they stay out of trouble.
You heard some comments earlier about the PA system. Can you describe how the PA system works and when it's used?
Yes, in the Davis Agreement, the 2006, it actually states when we can and can't use it. So we don't use it for intramural. That's something we can't do. We use it for events. We'll use it for a buddy walk. We'll use it for graduation. We'll use it for football, lacrosse, those type of things. But we don't use it for those activities.
Yeah, Bill, just looking at it, actually, I didn't even realize it myself, but on the A6, which is the resolution, paragraph 27 actually deals with it. So that may be...
And as like I said, I've only been here a year. I've read through these because I understand the relationship between the university and Radnor and wanted to make sure that we were following some of these things. That's the only reason I was sitting over there trying to, hey, it's in the Davis Agreement, so.
And actually, in the agreement, it provides the Davis Agreement is still in full force and effect, except any modifications that would have been made to paragraph 26. That's all I have.
Questions from the board? Thank you.
Can I make one comment just about the professional teams? You didn't get an answer. I'd like to try to give you what I would say. Sure. I've kind of mentioned that there's a lot going on in our stadium. We have camps going on all the time in the summer. We only had two real outside events. One was Radnor, one was Buddy Walk this year. That was it. That was it in the stadium. And even in the pavilion, we didn't have anything. So the amount that we use the stadium now and the need for us to use the stadium limits the amount of outside events that we can have. And that's not to say we wouldn't have them, right? We've had women's lacrosse contact us this year and a men's lacrosse league to play single games. We couldn't do it. It didn't fit in our schedule. So again, would it help us in recruiting? Would it help us in some of those things? Absolutely, it does. It helps us generate, not revenue, we don't make a lot of revenue off this. It helps us generate buzz around our lacrosse team or our soccer team or those type of things. So there's a benefit, we think, to the community as well, because these kids that are going to go and play lacrosse are in the community. So,
one thing, I believe Radnor High School did graduate from the pavilion this year. So there was...
True. Radnor and Upper Mary.
Do club sports compete there?
They do. They do. So, for example, our club soccer team will have a tournament in the fall, and not in the stadium, but they'll go compete over on Higgins. So they will compete, but they don't actually use the stadium that much, club sports, to compete. The way that we have it organized is Division I athletics gets first priority. Then it's actually the rec program. So it's the 5-on-5 tournaments that are for recreational use. And then any time outside of that, club sports will be allowed to go in and practice. So those are kind of how the priorities are set, and that's how we manage it.
Do you know either way whether the club sports, either in practice or competition, utilize the sound system?
They do not.
And one thing I do know from personal experience, there is my daughter who did not go to Villanova, but was going to Penn, and actually ended up playing club lacrosse at Villanova, and the lights went off in the middle of the game because they got terminated. So interesting about the timing on the lights. So
Okay,
that's
thank
all
you.
I have.
Thank you.
And that's all I would have, and just would request the exhibits be part of the record, please.
Without exception. Are there members of the public that would like to weigh in on the application?
I do. Anna Marie Hessman. ANNAMARIE space HESSMAN. First of all, thank you for the good questions. Some of the concerns that I have already come up in your very thorough questioning. I was very surprised to see the agreement on Monday. As an immediate stakeholder and resident, there have apparently been 5 months of negotiations, and we have not been privy to those terms.
Hold that thought for a second. Where do you live, ma'am?
Barleycone Lane.
Okay, thank you.
About 4 houses away from the closest southeast border. Areas of concern include how late, that seems to be the primary point of contention in the original appeal, how late the lights can be on, how much, which lights. It's a little confusing to try and follow the bouncing ball through all the different agreements, but I think 11 is too late. I've always thought it was too late. I'm surprised anyone would think, especially Sunday through Thursday, which are school nights and nights that professionals have to be up in the morning the next day. I was surprised that, any of those nights someone would think it was reasonable to have those lights on after 9 p.m., and I've thought that since I moved in. Also, the addition of the morning on none of the prior, I'm about to call them all agreements, but none of the prior documents addressed the morning time, which is most significant in the winter. And I was also surprised as a resident to discover that they were in the practice of turning on the lights around 5 a.m. some of the days and stuff like that. And so I'm concerned about the 6 a.m. hour, both because it only leaves 7 hours of sleep between 11 p.m. and 6 a.m., which is not reasonable for adults, and it's certainly not reasonable for school-age children. And just it's not even polite. I'm a classical singer. Every time I lived in an apartment of some sort, I would never practice before 9 a.m., but certainly not before 7 a.m. and after 9 p.m., because that's just respect for your neighbors. And you can say this may go away with this beautiful Musco system, but it's not there yet. And nowhere in this agreement does it say that these new terms of hours take effect only after the lights are in and after they work as promised. So I'm concerned that that is completely not addressed by the agreement. And I ask you, whatever decision you make tonight, to consider, if you are going to approve the variance, I'd like you to consider adding some sort of, I'm totally losing the word, a condition that between now and such time as those lights are less intrusive, that the minimum of 8 hours of sleep for an adult be planned in there. And think about the minor children. My neighborhood's teeming with small children. They need sometimes up to 12 hours of sleep, and they don't get up until 7 a.m. So especially as the winter hours approach, that's particularly significant. My other concerns about the agreement include the violations. I'm a little disappointed that we're going back in time and saying that a violation doesn't count. There have been numerous conditions where Villanova's not been cited, not had to pay a fine, not had a violation where something intrusive happened. And as someone who could be directly affected by these things happening, That bothers me, but the actual agreement, oh, wait, no. That's not, the agreement has, I'm shuffling too many pieces of paper here, excuse me. The agreement has 3 different paragraphs that talk about violations. And one thing that was not discussed tonight is why the township has decided to treat multiple violations as one. If they are agreeing to this settlement, why are they getting a kind of violations of the agreement? That's what we're talking about, right? Am I interpreting this correctly?
I think our purview is a bit narrower than that. That may perhaps have been an appropriate observation to have made last week at the Board of Commissioners, and I suspect perhaps that observation was made.
Yes.
But
if it's being attached to your decision, you're validating it, and I got no answer on Monday, quite honestly. And, if this is going to become real, like that they have a special multi-pass violation experience, I don't understand why that is.
Unfortunately, we're not an enforcement body,
Okay.
per se. I mean, we make determinations on disputes that are brought before us, but there's a different mechanism for enforcement. And
so you have to take this agreement as is what you're telling me. Am I understanding that correctly?
we can't modify the agreement. I mean, that as I said, the agreement itself is not before us for approval. There's a portion of the agreement that requires this board to take or not take action. So I don't know what I can offer there. Anyone else have thoughts? But, we can't go thumbs up or thumbs down on the agreement as an appropriate resolution of the issues between the parties. What we are being asked to do is modify a prior order of this board to include conditions that are set forth in the agreement and have them apply to the usage of the lights going forward. That's what we're being asked to do.
Okay. So if you have no purview to get rid of it, I just want to comment that I think it's extremely problematic. I've mentioned most of the issues that I noticed. Oh, the only other one is a couple times during the discussion of the usage. The original 1980 agreement talks about in the summertime versus, summer and vacation compared to during the academic year, Monday through Thursday. The new agreement talks about in session. And Villanova University has 3 summer sessions. One runs concurrently with the other 2. So that not apples to apples. And I just want to be really clear about that from a usage perspective. It's a large expansion. And it does sound from everything that was said that the actual usage is a little bit beyond the scope of the lighting hours that are the primary subject of the appeal. But my other primary issues are, can we get the paper on the screen?
Which exhibit are you referring to?
It's not an exhibit. This is just a summary of MPC 910.2.
Oh, can we have that turned on? I don't know if
Is it?
There you go.
There it is. Okay. I would maintain that number 3 and 4 are not met. At least not until such time as the lights changed, and even then, excessive programming could still be detrimental to the neighborhood if that is a question that falls under this agreement. And when we talk about it being self-created, what Mr. Cornelia left out of his little historical summary was that neighbors have been clamoring for help with this for a long time throughout the CICD process. Asking for help with it, asking them to resolve this issue. It's an existing issue for a very long time. And during the Musco presentation on Monday, the gentleman, who's Mr. Morris? Oh, I'm sorry. He mentioned that this technology has been available since 2008 or 2009. So I maintain that this is a self-created situation. Thank you.
Thank you very much. Any response or cross or?
Just a couple items. The agreement provides that Villanova shall install the lights by, I believe it said October. Obviously, if they don't, they would be in violation of the agreement. The township could cite Villanova or do whatever actions appropriate. I'm sorry, Norma. Okay. And secondly, as to the amount of the fine, actually, the zoning code provides an amount of a fine, and it says $500. This agreement actually increases the fine to $1,000 if there's a multiple violation.
Any other public comment?
My name is Martin Caulfield, C-A-U-L-F-I-E-L-D. I live on Hawthorne Lane in the Old Oak section of Radnor.
You need to be sworn.
Oh, I'm sorry. Yes, I do. I'd like to first start by saying I hope there's something that you can put in your decision that says if the lights are ever to be replaced, they have to. The university has to come up and speak to you about it, because apparently the lights were replaced in 1997. It was presented by the MUSCO presentation that the original lights were in 1980. They were replaced in 1997. And I would just advocate that if they're to be replaced in the future, that they have to come to the board to explain why they're doing it and how it would impact the neighbors. My second comment is during Mr. Zoller's presentation, he listed a bunch of agencies or groups that had a standard for the field to be at 75 foot candles. And I would say that that needed to have a caveat wrapped around it, because the NCAA requires, or excuse me, the NCAA has best lighting practices. It doesn't have minimum requirements. For non-televised events, as what Villanova's described they'll be using the field for, it's 50-foot candles is the best practice. And when it's televised, it's 75. So that stadium will be overlit other than the last hour at night from 10 to 11 if it's not being used for a televised event. And you might say, well, what's important about that? Didn't we just see a beautiful presentation from that company? And it was beautiful. I think the technology is great. However, Mr. Zoller made a distinction in this time that he presented it that he didn't make the last time. The last time we asked him about spill into the neighborhoods, and the atmospheric conditions have a potential for making it worse. And I can understand his comments that far away, it doesn't make an impact. But we're talking about the neighborhood that's not far away. We're talking about the neighborhood that butts up to the university. And my guess, and I'm not a lighting expert, is the likelihood of atmospheric conditions with 50-foot candles has less of an impact in the surrounding neighborhoods than one at 75. So I would advocate that the field only be lit to 50 when not televised or non-televised events, and then allowed to go up to 75 for televised events. Thank you very much.
Thank you. Any other comments? Roberta, good evening.
I do. Roberta Winters, 326 Williams Road in Rosemont. Although I am not an immediate neighbor, I would just like to encourage the zoning board to consider having the conditions before you make an agreement reviewed by the Pennsylvania Outdoor Lighting Council. We did have a public forum several months ago, at which time they said they would provide free counsel to the township regarding light issues. I think as development becomes more and more prevalent in our community, it's important that we have some guidance, and the Pennsylvania Outdoor Lighting Council is a great organization that may provide that and may give you insight before you make decisions that impact our neighbors. And I would also like to make note, I don't have degrees in physics, but I do know when I drive down the road, there are certain LED lights that bother me more than others. They may have the same foot candles, but there are certain colors that impact the eyes more than others. And one of the things that the Pennsylvania Outdoor Lighting Council and the lighting expert from Drexel University said, these can be health issues. They do have health impacts not only on people, but on vegetation and also animals that live in vicinities. So I think it's important that we try to get a broader picture about light issues in our community, and we have resources to do that. I know it's late, but this was something that has been brought to the attention of our township in the past. Thank you.
Thank you. Any other public comment? Okay. Nick, anything else?
I have nothing further to add. Certainly would entertain any questions from the board, if the board wishes.
Any further questions?
I have a question. So I'm struggling with, and I understand the agreement requires this body to deal with this issue tonight, but I don't understand why it's here.
Yes, this is, kind of when I went through the history, that's why I went through the history. In 1980, we had that decision, and that 1980 decision is what has caused all of this. Did Villanova violate or did Villanova not violate?
Well,
so
can I stop you for one
Sure.
second? Isn't the question whether they violated the 2006 resolution?
Well, I don't think there's any, as far as I know, there is nothing that's accused Villanova of violating the 2006 resolution, at least regarding the lights. I don't know if they had violated other. I saw Mr. Martin smile when one condition in there was pointed out to him. So to avoid any controversy in the future regarding the 1980 opinion, both the Township Solicitor's Office and myself felt it was best to resolve that now so that 10 years from now or 15 years from now, if it does come up before this board as to a violation, it would be this agreement itself, which Villanova certainly has agreed are conditions to any approval that's granted here, as opposed to a 1980 agreement when there's a dispute as to whether certain conditions were imposed at that time or not. So that's kind of why we're here in a nutshell. And since we're changing the lights, we would consider that to be a change of condition, and probably what Mr. Caulfield said, that if Villanova did change the lights again, they have to be back before here. And I don't think that's something the board has to say. I just think it's something that the zoning officer would require.
I have one more for you.
Thank you. Okay.
Do you believe this board, or can you comment on whether or not the board has the ability to impose? I mean, obviously, we have the right to impose certain conditions, but to the extent that they would modify terms in the settlement agreement.
Yeah, that's the problem. I mean, the settlement agreement, if you read the paragraph, it's pretty clear as to, and there's reasons, obviously, why we negotiated this, and it took so long to negotiate it. There was a lot of back and forth that went on with this. This wasn't something where there was comments made and then it was put away for 2 or 3 months. It was a constant back and forth as to it. And as you know, it was unresolved. At least 2 of the issues were unresolved until the commissioners' meeting last week.
Any other questions from the board for Nick? Okay, thank you.
Thank you. I think everyone, even, I know the neighbors have some issues on the hours. Everyone, I think, agrees that the design here is to benefit everybody.
Thank you. Would anyone care to make a motion to get discussion started?
Sure. I'll make a motion to approve the application, the request to modify this board's order from appeal number 1554 based on the additional conditions as set forth under the terms and provisions of the recently entered or negotiated settlement agreement.
Is everyone okay with that, that motion? All right, hearing no other objections, I might suggest that we limit the relief to incorporate those conditions set forth by paragraphs 1 through 9 of the settlement agreement.
I'm not sure why there's a distinction. You know, I have to analyze every single provision here, but my thought is that, you know, these are the terms that have been agreed to by the township and by Villanova. So I'm not sure I would accept that amendment. Now, you can make another.
Fair enough, fair enough. Second to George's motion?
I'll second to get us talking.
Okay, discussion?
Well, I'll start. I think what we've been living with, I guess, since 1980 is a somewhat vague order that no one was sure what the rules were, and life has been proceeding, and neighbors have been long suffering. And I see this as a vast improvement based on the evidence that was presented here tonight. You know, can it be even better? I don't know, maybe. But I think the world's a better place with this modification consistent with the settlement agreement.
So, I'll be brief, but, so I'll piggyback a little bit on what you just said. So that's the catch-22 for me tonight is I see the benefit in assuming that all these calculations and the technology is going to deliver what we've heard it, and I have no reason to doubt that it won't deliver what we've heard. To me, that's the vast improvement. My problem, my concern, or my hesitation tonight is I'm not in love with that settlement agreement, and there's terms in there that I'm not comfortable with.
Well, and there's the distinction between whether we're being asked to opine on the opinion as a whole or only do those limited acts that are required of us or requested of us under paragraph 11, which incorporates the conditions in paragraphs 2 through 9. My reaction to your observation, Rich, is I completely see where you're coming from, and reasonable practitioners could differ. But this is the agreement that has been negotiated by council for both sides and approved by the Board of Commissioners. In that respect, as it relates to the quality of the settlement agreement or the comprehensiveness of the settlement agreement, I don't think that's before us. That having been said, the settlement agreement goes away if we don't approve the conditions. So I think we do need to focus our thinking on that set of conditions and whether the application of those conditions is beneficial or harmful to the adjoining neighborhood and to the community. It's splitting hairs. It's really parsing what it is we're doing and not doing here. But I think, you know, our mandate is circumscribed by the MPC, and we're really kind of just looking at the request for a modification of a prior order of this board. And I mean, that's my reaction to that, but, you know, let's keep talking.
Yeah, and that being said, so some of my hesitation is contained in paragraphs 2 through 9. For instance, I hadn't thought about it, but one of the public comments was there's not an 8-hour time period involved in this agreement. It's 6 hours at best. So I understand what you're saying, and I get it.
And that point is well taken and well within what we were able to do, because we're trying to assess the impact on the community.
Right.
And whether the conditioning of the prior order is consistent with that.
Right, and if we're bound by paragraph 10, which is we either adopt 1 through 9 or we don't, right, it leaves the community in a situation where we vote no tonight, then what? Then we're right back to where we were before I joined this board.
Back to 1980.
Back to 1980, right.
The only comment I have is Exhibit A29. And to me, this is like, hello. The student goes to a school, they want the best they can have. And listen, 1980 and where we are today at 2019, but to me, this is a no-brainer. This is an improved product. I'm thinking of the student, that the safety and the experience. It certainly mitigates the lights in the community. It's never going to be perfect. A while ago, I heard someone talk about living next to the academy, what is the military academy, and they got really mad because they played taps. But you know, when you live next to an academy, that's what you expect when you go there. And it seems like the university's done an awful good job about trying to make the best situation we have. And I'm looking at just from a student's point of view, and which is part of the community. This is a no-brainer. This, I think it could have saved us 2 hours. You have a really good picture of what it could be versus what it is now. And the rest, because the students aren't going to look at what we're talking about from the ordinance, and it's getting them to have a better product. And it mitigates as much as it can to the community. And we're not talking about the sound system, we're talking about the lights. And I think they're different issues, and I see that. I live pretty close by, I live like 4 blocks away, but it seems to me this is the best solution given what they have to work with. That would be my overall comment.
I'm torn by the authority question and the role of this board vis-a-vis the commissioners. I don't think the local residents have been well served by the Board of Commissioners or by the settlement as it's presented to us. Nonetheless, the question is how to proceed. Do you have I guess either for the chair or for the solicitor, do you have an opinion on whether we can grant the relief approving the settlement agreement subject to incremental conditions?
Well, I don't think it's your purview to approve the settlement agreement, with all due respect. I mean, I think the only thing you can do, and I think the way you should consider this is there sufficient change in circumstances to modify your have you heard that? And is it sufficient enough to warrant the conditions that the parties are essentially presenting to you to add as conditions to this? And you've heard from the public as well.
But isn't there also a second prong of the test having to do with the impact on the community? So the question is whether it's within our purview to add conditions which we believe are necessary to minimize impact on the community.
Yes.
Yeah, I mean,
I think you do that without necessarily approving the settlement agreement or not. It's the conditions that are the issue. Do you feel as if you've heard enough that warrants adding these conditions to a prior order? If you don't do that, the prior order stands. Now, obviously, there's going to be a lot of other results of that decision, but that's where you would be.
Yeah, Bill, I hear what you're saying, and I think the challenge before us is we should be looking at these conditions independent of what happens to the settlement agreement if we want to add additional conditions. We should be acting as we would in any other circumstance to make a determination of whether these conditions are injurious to the public or they aren't. And if we find that they are lacking or that they need modification, there is nothing that constrains our mandate to condition what is in front of us. There may be a consequence to that. But
I'd like to.
that's the challenge.
I'd like to propose an amendment to the motion that, to add two conditions. One is that the approval is limited to the light system as presented and as referenced in the settlement agreement. And should that light system change, that an additional approval would be required from the board. And second, that the sound system at the stadium be limited to use during intercollegiate events after sundown and before sunrise.
Is there a second?
I'll second that.
Okay, discussion on the amendment first. So Bill, on the first proposed condition, if they want to change out the lighting at some point in the future, they have to come back.
Again, I know there's an issue about referencing the settlement agreement. The settlement agreement refers.
Well, it makes specific reference to Exhibit C.
Right. And I think what we're saying is we're approving Exhibit C, and to the extent a new system, an augmented system, et cetera, it would pose different issues in terms of our assessment, and they should have to come back.
Yeah, and my problem with Exhibit C is I don't know what it says, because it's got a couple pages from a larger presentation in very small type, but I would have expected, and Rich, I'm heading in your direction now, I would have expected far more specificity in terms of the terms and conditions of the lighting plan that would have been acceptable and included as Exhibit C. Instead, we get the cover page, which is very nice, the second page, which no human eyes can read, and the third page with examples of lighting fixtures and not a whole lot else. I mean, that's pretty thin gruel from where I'm looking at it. And, reasonable minds could differ as to whether that's an appropriate condition, or exhibit for something as fundamental as the settlement of this longstanding resolution, set of issues.
Mr. Chairman?
Well, I think the Exhibit C, I guess the question is, when are you ever going to know what a violation is of Exhibit C? And we can't speak to that. I think maybe it's stating the obvious that if they ever change the lights again, they have to get consent. The township will have a right to say something about that. But if we're uncomfortable that it's not that obvious, I'd have no problem on the First Amendment that you've suggested. The Second Amendment, I do have a concern about. I mean, we haven't heard any evidence whatsoever about loudspeakers or PA systems. I don't know if they're too loud. The neighbors will say they're too loud, but we haven't had anything to review about that issue. I can't pass judgment on it. It's not part of the township. Their job is to look out for the residents, and that's what they've been negotiating for the last 6 months. I have to assume they're keeping the residents' best interests in mind. So on the Second Amendment, I would not agree to the Second Amendment.
Bill, would you consider altering the proposed amendment to include only the first condition and foregoing the second?
Not and still voting for the resolution, no. I think we should vote on the amendment.
Okay, let's call a vote on the amendment to the motion. Again, the amendment first adds a condition that the applicant will return to the township for approval of any change in the lighting from the lighting that is specified on Exhibit C to the settlement agreement. The second condition relating to the use of the sound system at the stadium, limiting that use only to, and Bill, get me if I'm not getting this correct, intercollegiate events after sundown and before sunrise? They would not be used? It would not be used?
It would not be used before sunrise and after sundown except for intercollegiate athletics.
Thank you. Okay, so all in favor of that amendment, please indicate by saying aye.
Aye.
All those opposed? No?
No.
Okay, so the amendment is stricken. Are there other amendments?
So, I'm sorry. So I would move that we keep the first condition, and for fear of not stating it properly, I'll go by your notes.
That would
Mr.
be the
Chairman.
condition that in the event that the university wished to change lights in the future, other than as set forth in Exhibit C to the settlement agreement, it obtain the approval of the township.
So can we actually modify that to, other than set forth in Exhibits A12
That was
through
good. That was going to be exactly my suggestion. I mean, the Musco system and all of the exhibits that were
20
presented.
8 or 29, I don't know where it ends. But yeah, the packet that was presented tonight.
Oh, okay. So we'll further revise that amendment to require the university, in the event that it wishes to change the lighting system at the stadium to a system other than that identified in Exhibit C to the settlement agreement and consistent with the testimony presented at this hearing. Jeez, I'm sorry, Norma. Let's take it from the top. The university, in the event that it wishes to change the lighting system at the stadium from that which is described on Exhibit C to the settlement agreement, and as explained in Exhibits A12 through A29 of the presentation at this meeting, and now I'm scrambling, and the other evidence presented at this hearing, such a change would require township approval.
Right, and then I would make a second condition,
Township approval or zoning board approval?
zoning board approval.
Okay, then
Yeah.
we can make it zoning board approval.
But then I think I would also add, I'd like to see at least an 8-hour period where there's no lights being illuminated.
That would be a second condition. So a minimum 8-hour dark period during any 24-hour period?
Correct.
Okay. Okay, so there are now a second amendment with two new conditions. Discussion on that amendment. George?
Again, I favor the first part of the amendment, not the second. Can't support that.
Let's call a vote. All in favor of the amendment with the two new conditions, please indicate by saying aye.
Aye.
All opposed? No.
Nay.
3-2, that amendment is going to carry. So now we go back to the original motion, which is to grant the relief requested in the application, adding specified conditions to our prior order 1554, subject to the addition of 2 additional conditions as described in the amendment, the first being the requirement for zoning board approval for any change in the lighting from that specified in Exhibit C to the settlement agreement and the testimony presented here this evening. And the second, requiring a minimum dark period of 8 hours. Let me be more specific. A minimum period when the lights are not used of 8 hours during any 24-hour period. Discussion on the amended motion, if any.
Just as somebody who's close in there to the facility, I appreciate the thought given to the other members, by the other members of the board. Appreciate the amendments. I'll be voting against it because I think the expansion of the lights as late as they're being expanded into the evening is contrary to the interests of the community. But I do appreciate the attention and thought provided by the other members.
I'm just scratching my head how this 8-hour thing works. So is it just it's going to be a day-to-day situation? Like for if they're done at 11:30 at night, you're just going to go forward from there for 8 hours, or what?
Not my motion.
Yeah. Eight continuing hours.
So the problem, as I see it, and which is why I raised the motion, and you raise a valid, practical question, but the concern is that the lights are on from 11, or they end at 11 p.m. under the proposed modification, and they can come back on as early as 6 a.m. That's the concern. And that's what I'm trying to address. So maybe I didn't articulate it well, and it requires further fleshing out. But that's the concern, is that the way it's presented to us, it's at best 7 hours.
I think it works. I think, it suggests once the lights go off, they have to stay off for at least 8 hours. And I think that if that's left within the flexibility of the university, they could presumably manage around it. That was what I just said. I realized was imprecise. I mean, if they turned them off at 5 and turned them back on at 7, but I mean, again, we have a great counsel. He's going to figure out how to draft this.
Our former our former interim counsel.
I'll be out there to make sure they go on and off.
We're in a bit of a pickle here. Newsflash. I'm with Scott in that I truly believe that the technological superiority of this application as opposed to the current lighting has a lot to say for whether we should approve the relief that's granted, or requested, excuse me. But there are a couple other challenges. One is obvious, well, I don't know if it's obvious or not, but there were probably many, many, many options that were considered between the parties over the months and months that the settlement agreement was negotiated. And the settlement agreement ended up the way it did. And it was agreeable to both sides, and it was approved by the Board of Commissioners. I think it may be fair or unfair to assume that if there were any time limits that were acceptable to both parties, they would have found their way into the settlement agreement.
They didn't define stadium events. I mean, I think you're giving folks
Well,
credit.
see, we have to take the agreement that was in front of us, but they tried to define stadium events.
And Mr. Chairman, as your solicitor, if this decision needs to be supported down the road for some reason, it would have to be based on your record that you've heard before you. So I don't want to. We've gone a little too far afield
Fair enough.
on a
Fair
couple
enough.
areas. So that's, and I'm very hesitant to ever rein back any discussion. But I think once we start doing, or you start taking into consideration something that wasn't in the record, you may be running into issues or opening up problems.
Thank you for that. And I need to be reined in from time to time.
I don't
So
mean to
appre-
direct that to you, I meant the entire board.
Well, I think, yeah, I mean, that's probably also an appropriate observation for the condition that we were considering about the sound system. So now we're at a place where we're going to consider taking action on relief that is not on all fours with what the settlement agreement has requested. We have added conditions.
On one issue.
On one issue, that's right. And I don't think that, well, actually on two issues.
Just the 8 hours, that's the only issue.
They don't have to come back to us if
I think that happens
implicit?
no matter what
You think
we
it's
say
implicit?
up
Okay,
here, yeah.
fine. My concern is that the motion is adopted in the form that it's in, and the parties walk away from the settlement agreement. So at the end of the day, we need to ask ourselves whether 80% of a loaf is better than nothing. And we're doing so in a context that, enforcement, obviously, of the prior conditions on use has been difficult. And I'm not certain that enforcement of these new conditions is going to be any easier. So I'm in a real problem spot in that I think that this is a far better adoption of the relief being requested is a far better situation than where we find ourselves today. And my concern would be whether the addition of that condition jeopardizes the substantial improvement in the condition that is offered by the relief that's being sought. So that's what I'm struggling with. So notwithstanding the fact that the motion has been amended, I would respectfully ask whether there's the ability to reconsider that and take the application as we find it. I'm not saying that the additional condition is inappropriate, but I'm just saying that I don't know that it's a compelling enough issue to add and therefore jeopardize the settlement agreement as a whole. So I'd ask whether the board might consider revisiting the amendment of the motion.
Since I made the motion, I'll address that. The intention is not to stand in the way of a deal, and I agree. It's based on what we heard tonight, what I heard tonight, it sounds like it's a far better system, and it should improve the living conditions, for lack of a better term, to the immediately adjacent neighbors. But then I roll back to my original concern, which was that agreement is just there's undefined terms. There's certain questions that we didn't ask, so it's not in the record. But what's the academic session? It sounds like the academic session is 11 months out of the year. If you know what somebody.
Well,
from the public
sometimes
said.
agreements are ambiguous on purpose.
Sure. And then, so we get back to then on the other side of your coin is, so we remove the 8-hour piece and we adopt it with the way it is, Exhibit C, with the testimony we heard. We run the risk of denying that relief anyway, if I'm hearing what I'm hearing from the board.
I mean, we could vote on the motion as amended. If it doesn't pass, someone can make another motion?
I guess my only comment would be is they worked really hard for a settlement. It's not perfect. It's kind of out of our preview. They didn't really ask us. It was defined. I don't know that all parties were represented. I know there's I'm sympathetic to some of the neighbors, but at the end of the day, I think we got a little lick in. We said there was 8 hours between it, but it is what it is, and we could argue it all night long, but at the end of the day, both parties agreed to it, and so I think we should support it, and I think if we can amend it with the 8 hours between, it's a little win for the neighbors. They know that we're very sympathetic. I mean, if you've been listening to this for the last 3 hours, you know this hasn't been an easy decision, and there's certainly a lot of back and forth, but I would be very supportive if we adopted the resolution to the 8 hours and keep the amendment the way it is and call it a night.
How would the parties react to a conditioned approval? With the sole condition being the one that we're talking about now.
Well, the first condition, I think that's implied in the agreement. If the lights change, we would have to come back here. That's why, we're here anyway, so I think that's implied. This agreement was negotiated for 6 months. The agreement provides that if this board provides any other conditions, that this agreement's null and void. By imposing the 8-hour condition, it is another condition which in effect would null and void the agreement. So that's the concern that I have with everything here, in discussion. And thank you for asking me about it, because I was sitting here patiently.
We were going to get to you.
Yeah, I didn't know if you were going to.
We're going to get to Peter also.
And that's just my concern. This was negotiated and.
Well, Nick, are you saying that the agreement is voided ab initio, or could the parties waive the provision for an unconditioned, unappealed?
Well, certainly they could modify. You could modify any agreement, but then it would have to be going back to the Board of Commissioners, getting their approval for the modification, and then Villanova also modifying it. And believe me, I do not want to go back to the Board of Commissioners, but that's what it would take.
Peter, do you have any thoughts on that?
Just to mirror what Nick said, I mean, this was negotiated by my office with Nick. It was then presented to the Board of Commissioners, who then adopted it. I have absolutely no authority to agree to any change to it, and it says what it says.
Thank you.
Yeah, go ahead. Yeah, I mean, we wouldn't be asking the township to agree to it, nor would we be asking Villanova to agree to it. What is being proposed is to grant the relief with certain conditions. And, the university could proceed with an installation subject to the conditions, or it could proceed subject to the conditions only after the township agreed to amend the settlement agreement to make it consistent with the conditions. I still think that part of the view here should be the needs of the community. We have evidence about the issues associated with the duration of the use of the lights. I think it's a reasonable amendment, and I'm still in support of the amendment to the resolution.
If I may just add, and this is paragraph 10, page 4 of the agreement. This agreement is expressly conditioned upon an unappealed, unconditioned approval by the zoning hearing board of a modification of this decision. So in effect, that would violate this agreement that we entered into. As I
And you
mentioned.
can get on the phone tomorrow and make a two-sentence change and then sign it,
And
right?
No, it would have to go back to the Board of Commissioners for their approval, too.
Well, you could send a colleague instead of going yourself.
But this has been negotiated for such a long period of time. And the other evening, I was under specific instructions that if it's not approved in the manner that you see here before you, to walk away from it. And so that's my concern, it's been going on for a long time, Bill. And the only other thing, too, let me just make one comment. I'm sorry. Let me just make one final point. As presented by Musco, this is a completely different light system. I would tend to agree, if we had those old lights, yes, we need an 8-hour system. But you heard testimony here that you have 0 spillage foot candles. You have elimination of, I believe the testimony was 98% of the glare. So I don't see this keeping people awake for a period shorter than 8 hours. So I would just request the board to approve it with the conditions that were agreed upon by the township and the school.
It feels like we're forced.
Oh, I'm sorry. No, go
I was
ahead.
going to say, it seems like we're forced to in a corner, and you have no choice. And it seems like I don't live right next to the lights, but we're trying to be as sympathetic to the neighbor that lives right next to it. I don't think it's the worst of plan, but I sure hate to throw this out. And I sure hate the students not to get lighting because there wasn't a little flexibility in the one little thing we're trying to convey, which is we're hearing testimony from residents that say, hey, it's fair to have 8 hours between spans. They do it in shift work. They do it all over the world when it comes to understanding what's happening. I don't live next door. I don't know what it's like. I don't know where someone's window is. It sure looks like it's an awesome lighting system that won't affect them next door. But if it's 8 hours and that's what we're requesting, to throw this whole thing away, that just seems to be wrong. And so much money and effort has gone to make this come to fruition that we're going to throw this out for 2 hours. And we're forced to either decide to take it the way it is or walk away. And it's going to cost a lot more money. And it'll be another year before the students get good light. It'll be another year before the residents get a little relief on better lighting. It just seems to be wrong that we're forced to say yes or no with no condition.
Yeah, and my reaction, aside from other comments I've made this evening, is that the Board of Commissioners, by approving the settlement agreement, were, as George and others have noted, presumably working in the best interests of the community. And that process reached a conclusion in the acceptance of the settlement agreement as it was and with the conditions that are in it. I'm with Scott. I cannot, in good conscience, risk throwing out all of the improvement that is going to result from the parties' work for a single condition which, considering the technology, I'm not even sure is the same concern as it would be with the existing lights. I mean, if these magical illuminating machines here are really able to do what it is we've been told that they can do, and in the manner that that they do it, I believe the surrounding neighborhood will see immediate benefits, or perhaps not see immediate benefits, because they'll be in the dark as opposed to where they are now. And that's why I'm going to vote against the motion when we get to the vote. But I want it to be on the record as to why I'm doing it, because I'm in favor of the proposals that have been put through here, but I'm concerned that we lose the benefit of what the parties have agreed to by attaching the condition.
So Yeah, and you know, I guess my concern is, and it comes right back to where I started this, which is I still don't really understand why this is in front of this board at this point. I don't know why we're modifying. The parties thought it was unclear what was done in 1980, and they're asking for clarity here, but it opens up the door or the window for this type of discussion and to address these types of concerns. So I agree. Look, I don't want to stand in the way. In my professional life, I never want to be the reason why something doesn't close. I do a lot of transactional work, and I most certainly don't want to be the reason that something that's been going on for the last 8 months blows up. But by the same token, they brought it here, and we're obligated to deal with it.
Well, then, before we call a vote, Gus, procedurally, can we propose another motion that's also on the table, and we can vote on them in order?
Correct. I mean, while you're in session, the chair can entertain another motion, and there may or may not be one after this vote. But yes,
Correct.
so yes.
Okay, so I would like to propose a second motion, exactly similar to my first motion, as amended to reflect the first point, but excluding the change in hours.
And George, when you make reference to the prior motion, that is, or are we including that they have to come back for?
Yes, yes,
Okay,
yes.
so they come back for changes.
Yep.
Well, query whether that's a condition. That would.
Well, I don't think it is, but.
If they decide it's a condition, then go back to the township and get it changed. Because what we've heard is everybody says that's what's intended. But we also know that the only thing we can rely upon is either what's in the settlement agreement or what's in the order. So if it's not in the settlement agreement and it's not in the order, in 5 years, we're not going to be able to rely upon testimony of the university saying that's what was intended, because we know that they've argued in this case that what they say is intended is not enforceable unless it's in the order or in an enforceable agreement. So we either can include it or not, but if we don't include it, we run the risk that we're not going to be able to hold them to it.
Yeah, so just to be clear, my motion does include that requirement to come back before approval by the zoning board.
And
then we would need a second, I guess.
Yeah, yes, a second for that motion.
And just to make it clear, George, are you including as conditions to this approval items 2 through 9, or I mean, I thought that was a point of.
Subject to all the terms and provisions of the settlement agreement as written. Yes.
I have a second for that motion. Even for purposes of.
Yeah, I'll make the second.
Okay. All right.
You can second.
No, I don't think I can.
Yes, you can.
I just, I keep begging all night. Yeah, my concern about the implicit term of coming back is that the agreement requires, well, no, maybe it is implicit. Now that the agreement requires on or before a specified date, the university shall install, erect, maintain, and replace the stadium lights in accordance with the design parameters set forth in the plans. So if they ever want to replace it with something other than what's in the plans, they have to come back. Okay. Does that, Bill, address your issue on?
I'm voting no.
Okay, we have two motions before us. One with the 8-hour condition, the other with no 8-hour condition, both with the requirement that they come back for changes.
I have a question. Can we make a motion saying that we'll agree to everything, but would the city council or would the Board of Commissioners consider reviewing the request to limit the hours. So yeah, we'll approve it, and we know they don't have it, but would they consider listening to reducing it one more time, so that we'll approve it, but it'll be on them if they don't want to reduce it, but that we've made mention, because we don't have the preview to do it, because it's a yes or no thing for us. But at least we've been sympathetic and try to get them to reconsider what we hear from the neighbors, that they would like an 8-hour span.
I think the record reflects the care with which we're considering the issues before us. My concern would be something like that would be, I don't know that it would be effective to produce any action. So I'd probably, my preference would be to just avoid doing that.
Yeah, I don't think,
Because we only have 2 motions.
and I don't think, under the MPC, I don't think you could.
Yeah, okay. Yeah, I mean, yeah. The board's legislative, and they're going to do what they do, and we do something different. Okay, I'm going to call the vote on the first motion, which grants relief to modify our prior order 1554 by inclusion of the conditions that are specified in the settlement agreement, with the 2 additional conditions that the university has to return in the event that they want to change the lights, and that there's a minimum period that, of 8 hours that the lights are off after they are turned off following their use. All in favor indicate by saying aye.
Aye.
All opposed, say no. No. So that motion has been,
That means the whole thing is null and void, because we changed the terms of what the agreement is.
yeah, that's your intent.
Right.
That's why you voted that
I
way.
understand.
Okay. It's unnecessary to consider the second motion, as it's contained in the first motion. That being the case, Gus, anything else? 3-2? The vote was 3-2 in favor of the relief with the 2 conditions. Anything else for us to do this evening?
No, from my standpoint, no. Thank you, Mr. Chairman.
Thank you, everyone. We're adjourned.
Thank you for your time.